Hello and welcome to the Equal Means Equal ERA Town Hall. I'm your host and moderator, Camila Lopez, and I am so excited to be here with you to have this crucial and timely conversation about the Equal Rights Amendment. Our goal today is to encourage an inclusive and transparent dialogue regarding ERA strategy for 2021 between the leadership and legal advisors of the major national women's organizations, grassroots advocates, and the general public in order to build unity and find consensus. We are honored and grateful to be hosting the following major national women's organizations who have been focused on ERA ratification: ERA Action, Feminists in Struggle, Feminist Majority, Generation Ratify, Katrina's Dream, the National Women's Political Caucus, the National Organization for Women, Pass ERA, Vote Equality ERA. We would also like to thank the following organizations for their support: Center for Common Ground, ERA Minnesota, ERA Now New England Coalition, the Georgia League of Women Voters, the League of Women Voters of North Carolina, the North Carolina ERA Alliance, the Southwest Voter Registration and Education Project, the United Coalition for Humanity, and United Nations Women. Lastly, we would like to thank the 86 organizations, corporations, unions, churches, and fellowships, including the International Brotherhood of Teamsters, the Screen Actors Guild, and the Church of Christ, that all signed an amicus brief in our lawsuit. You can find the full list of amici on our website, equalmeansequal.org. There are many of you listening who have been working on this amendment for over 60 years. There are many of you here today who have been dedicating the past 5 years of your lives to achieving ERA in the final 3 states. To all of you, we are deeply grateful for your work and for your presence here. But there are also those here today who may not know exactly what the ERA is and why we need it. And to that end, I would like you to indulge me while I play a 5-minute clip from the documentary Equal Means Equal about the history of the ERA and why we need it. Thank you.
Most women in this country believe in general they're protected under the Constitution, and that is not the reality.
Well, that's just, if you read the Constitution, you can see it says all men are created equal, not all human beings, not all women and men.
A constitutional amendment is a guarantee. You have a bad election, they can't take away your rights. It's the guarantee from one generation to the next. Women don't have that. In the original Constitution, they purposely excluded women. That's the history. We can deny that it existed, but it did.
This Constitution was written at a time when we had slavery, and the status of wives, the legal status of wives, was the model for the legal status of slaves, because we were chattel.
The reality is you couldn't own property, you couldn't vote, you couldn't, you were essentially the possession of your father until you married.
There were many brave people sheltering slaves on the Underground Railway. But when Susan B. Anthony and other women sheltered runaway wives, then some of the abolitionists themselves, the men said, now you're going too far. They really do belong to their husbands.
The new 14th Amendment guaranteed the right to vote regardless of race, but only for men. Black women, and all women, were not given voting rights. It also added the word male into our Constitution for the first time.
Women had a long, hard fight ahead of them, jailed, beaten, and force-fed just to get the vote in 1920.
Then, suffragist Alice Paul proposed ending inequality in one fell swoop by adding a few choice words to the U.S. Constitution to protect and include women.
Equality the law shall not be denied or abridged by the United States or by any state on account of sex.
The ERA was introduced in every congressional session starting in 1923 with no success. It was only voted on 3 times in 49 years. Then, in 1970, members of the newly formed National Organization for Women stormed Capitol Hill, demanding the ERA be heard by the full Congress.
We are people who are fighting for our very economic survival.
Congress agreed to vote. It passed with flying colors in both houses. President Nixon endorsed it. The ERA was sent to the 50 states for approval. 38 were needed to make it law. In the first year alone, 30 states ratified the ERA. When the deadline came in 1979, 35 states had ratified the ERA, 3 states short. Congress extended the ratification deadline until June 13th of 1982, but
time ran out for the Equal Rights Amendment today. The 24-word statement pledging equality for women under the Constitution fell 3 states short of ratification.
But it has never been what the people wanted.
The Equal Rights Amendment would improve life for women and men in many, many, many countless specific ways.
It's not a women's rights amendment, but it's an equal rights amendment so that men would benefit from these laws, especially when it comes to their private lives involving their families and their children.
The most important thing that we'll do, it will set the principle in stone, and then it will be a starting point.
Whether it's the high school team getting Title IX funds, adequate uniform and support for travel, whether it's the rape victim who expects to have a rape kit tested.
The presence of an ERA significantly increases the likelihood of a court applying a higher standard of review, which in turn significantly increases the likelihood of a decision that favors the litigant who's alleging sex discrimination. That's very, very important and valuable.
Dr. King once said that we're all tied together in a single garment of destiny. And he went on to say that we are interdependent and we're interconnected. Injustice anywhere is a threat to justice everywhere. Until women have an even playing field, the nation has not lived up to its high creeds.
Thank you. Thank you for watching that clip. Since the film was released in 2016, the landscape for ERA has changed dramatically, with the remaining states we needed ratifying the amendment. Nevada ratified in March of 2017. Illinois followed in May of 2018, and Virginia became the 38th state in January of 2020. This completes the ratification process as outlined in Article 5 of the Constitution. But because the ERA was given a 7-year deadline, later extended to 10, that was written into the preamble of the amendment, there is controversy around publishing and adopting the amendment today. The U.S. archivist wrote a letter in 2012 promising women that he would publish the ERA if we got 3 more states to ratify. But when this very archivist received a letter from the Trump Department of Justice, then under Attorney General William Barr, directing him not to publish the amendment, he refused to publish ERA. Equal means equal, and the attorneys general of the states of Virginia, Illinois, and Nevada sued the archivist to compel him to publish the amendment, as is his mandatory non-discretionary duty. Attorneys general from nearly half the states wrote a letter last year agreeing with our legal arguments about why the ERA is valid despite the deadline. But both cases were dismissed for lack of standing in first courts. Equal means equal appealed their case to the First Circuit Court of Appeals, and the oral arguments will take place on May 5th. The other case does not appear to be moving forward. The United States House of Representatives passed a bill to remove the deadline on the ERA. The bill is in the Senate and has yet to be voted on. So that is the status of the ERA at this very moment. Many of us are confused and concerned by the present politics surrounding the Equal Rights Amendment, given that the new Biden-Harris administration has taken over and has not yet rescinded Attorney General William Barr's letter to the archivist, or have they ordered the archivist to publish the letter? The Biden Department of Justice is also continuing to oppose the ERA in our lawsuit. It is asserting the very same anti-ERA argument DOJ asserted against us when the lawsuit was first filed, instead of simply agreeing that the ERA is the 28th Amendment and that archivists should publish it in the Constitution. It is into this fraught and convoluted environment that we seek to use our collective intellect and skill sets to have the ERA published in the Constitution for American women in the immediate future under the present administration. Eileen Davis has been a consistent, steadying force throughout the past push for ERA, from her home state in Virginia and nationally. And before we begin our organizational presentations, Eileen is going to say a few words. Thank you so much, Eileen, and thank you for saying a few words.
Hi, welcome everybody to this call. We are at a cross point in a 100-year battle that is not stopping. We are still continuing on. I wanted to talk to you today about the focus of this call today, and this call can best be as a call to unity. We have to come together. There are a lot of different, because we thought we were going to ratify and certify and publish, and we were going to celebrate. When that didn't happen, there's been a lot of discourse, frankly, that has arisen. And for those of us who have been on this fight for many years, we've seen this. We've seen this before. We've seen the stress that comes from having something you believe is done, and then everybody's saying, you know, not so fast. So what I want to say today is I want us to have an open dialogue today about the issues that face us, how we can come together. I think the thing we most have to remember is that we need to stand united, not divided. We can't let side issues distract us. We have to make sure that we stick to the goal of all means all, and that anything other than all means all is a distraction argument. I would like everyone on this call to please consider reading the book, Why We Lost the ERA. One reviewer, and here's the book right here. It's by Jane Mansbridge. And one of the reviewers noted that the book uncovers a significant democratic irony, that the development of self-defeating contradictory forces within a democratic movement in the course of its struggle to promote its version of the common good. It is very important that we remember that and take this historic lesson to heart. If we've learned anything from our feminist past, it's that if we only succeed when we raise each other up. We have fractured and caused great harm to ourselves in the past. In the 100 years ago, women who fought for suffrage were otherized and forced to the back of the parade. In the 70s, the chasm that was fomented by ERA opposition between women who worked outside the home and so-called homemakers was a successful divide and conquer strategy that our movement under-responded to, in my opinion, and was a key factor in the collapse of the ERA in the 70s. So, here we are today. We are either going to really unite and move forward together, or we are going to make those similar mistakes. As the sage 500-year-old quote warns us, those who don't know history are doomed to repeat it, and I reserve the balance of my time.
Fantastic, Eileen. Thank you so much. I think that all of us here today agree with that. And that's why we're here, and that's why we're all participating despite different points of view, different strategies that we may be employing. We all agree that we have the same goal, and that's adoption of ERA. So I am now going to introduce each organization in alphabetical order, and they will have the floor to talk about their work, discuss their point of view and strategy on the ERA. At the 8-minute mark, if they're not already finished, they will be given the 2-minute bell, letting them know to begin wrapping up. I don't know exactly how that's happening, but we'll all discover it together. The National Organization for Women will complete the presentation period because they were unable to come at the beginning. And then we will move into the Q&A period. We welcome any and all questions, and we will be collecting them throughout the presentations. So please put your name and your question in the chat as soon as you think of it. Even put your email, just in case we want to get you on camera somehow. Someone is going to be gathering them up and giving them to me all together when we start the Q&A period. And I will try to get to as many of them as possible. After an hour of questions, we're going to focus on strategies to achieve our goal that hopefully we can all agree on. If you have strategy suggestions, please put them in the chat, and we will collect those too for discussion in the final portion. And in the next day or so, we will send out a summary to everybody of which strategies we came up with, what we agreed is most effective and critical. And we thank you so much for your participation. Without further ado, we will begin the presentation period with Arlene Rocky, who is the attorney for the amici in the case defending the Equal Rights Amendment. Thank you, Arlene. You're muted. Arlene is muted.
Okay, sorry. Okay, I appreciate the chance to talk to everybody today, and I'm very glad that everyone came. I am representing the amici or amici curiae that are friends of the court. There were 86 of them in the First Circuit Court of Appeals. And I've been working on this case since last summer, I think around June. And in doing the research for the briefs and learning more about the resolution that was passed in the House, and the same exact language is been sent to the Senate, and also learning about the OLC, the Office of Legal Counsel opinion that told the archivist that he was not allowed to publish the ERA, even though it had been ratified by 38 states on January 27th of last year. And I was sort of behind the scenes and was talking about a better way to do the resolutions and some other things. So since we're talking strategy, I just want to try to explain to you what my research showed and what I have done. I put in the chat 2 posts, and they have links to them. The first one is what I'm going to talk about first. And what that is a substitute validation resolution. The concern that I have with the resolution that was passed that is trying to, quote, get rid of the deadline is that, number one, it was written in 2019 before 38 states had ratified the ERA. So I researched the cases, that the other Supreme Court cases that had talked about amendments. And I found that Congress really has the authority to validate an amendment. And they did this with the 27th Amendment, which took over 200 years to be ratified. And what they did is the archivist published it because it didn't have a deadline on it anywhere. It was put in the 1700s and put out to the states in the 1700s. And so the archivist published it, and then Congress did a validation resolution. And I looked at that. And so this is what I found out. The idea, there are things that have to be included in the resolution for it to protect the ERA. And one of the most important things is to make it so that it is to be considered a non-justiciable political question. So that means that it's something that the courts, the Supreme Court even, usually do not touch. They respect the three branches of government, and it's Congress's and legislators in states decisions of doing things that are considered political questions. And so what I looked up was how to make it more likely that it would be considered a political question. The other thing I'll go ahead and tell you this part. It has to say that the amount of time, and this is the part that just sidesteps the deadline and makes the deadline totally irrelevant. What they need to do is put in the resolution that the amount of time that it took from the date that the resolution was sent to the states back in the 70s until January 27th, 2020, when it was finally ratified by 38 states, was a reasonable, quote unquote, reasonable amount of time given the circumstances. And it's more specific in the resolution, but it's basically looking at a lot of different circumstances. And so that means the deadline doesn't matter anymore. You don't have to say we're removing the deadline. In fact, in the current resolution, in my legal opinion, by saying we're removing a deadline, it's saying the deadline was valid. We don't even think the deadline was valid. We think it is an unconstitutional nullity, and I'll talk about that in a minute. Anyway, the other thing is that to have this the ERA validated as the 28th Amendment, the other important part is that you have to say that the ERA, Congress would have to find in this resolution, that the ERA has retained its vitality. In other words, it's still needed from the time it was put out to the states until the time it was ratified on January 27th of 2020. So that is something that's a political question. And also there's a reasonable time in talking about the different circumstances, and they could do hearings to get evidence about these things. That would be helpful for finding that's a political question. Those are two important parts. The other important thing is, and the most important thing is to actually say in the resolution that the ERA is the 28th Amendment, that it was fully ratified on January 27th, 2020, when Virginia became the 38th and final state necessary to ratify it. The resolution that was passed in the House does not declare that it is the 28th Amendment. It talks in prospective language because remember, it was written in 2019 before the ERA was ratified. So it has to say it already is the 28th Amendment. And that the reason is that the Supreme Court has said that an amendment doesn't become law and part of the Constitution when the archivist puts it in there. It actually legally becomes law on the very date that it's finally ratified by the certain number of states that are necessary. And so those are just the most important things about the resolution. And at the end of the resolution, it can say that the archivist should publish the amendment. And the archivist should then publish the amendment because Congress is using its proper power and checking all these boxes, and there's no reason for the archivist not to publish. The other thing that could happen is the president could just tell the archivist to publish the ERA in the Constitution as the 28th Amendment now. And then after it's published, just like what happened in the 27th Amendment, Congress can do this validation resolution, same language, except for the very last paragraph, which tells the archivist to publish because he would have already published. And it would protect the ERA from further court intervention, just like they did with the 27th Amendment in 1992. And this is just so important because one of the other issues that I find with the resolution that was passed in the House and that is pending in the Senate is that because it doesn't declare the ERA to be the 28th Amendment, it leaves it open for having injunctions issued to stop it. And we don't want injunctions to stop it. We want it to be said that it is the 28th Amendment. Another thing I did, because everybody's talking about the OLC memo, and then the Virginia, Illinois, and Nevada case was dismissed by the district court judge in DC, in federal court, and that is the trial court. That's the first court. And I put my timer on and I forgot to push start, but I haven't heard the bell yet. So anyway, I'm going to keep going. What I did is the problem with the DC opinion is this. For courts to make an opinion, to make a ruling, they have to have subject matter jurisdiction. That means jurisdiction is the power to hear the case, and the subject matter is the type of case they're hearing. Part of subject matter jurisdiction is standing. That means do the plaintiffs who brought the case have the power to come to court, the authority to say, we want this fixed? And that's called standing. If they don't have standing, the court does not have subject matter jurisdiction. And this court in DC said they didn't have standing, and I'm not going to go into all the details why, but you can read the opinion. But he okay, thank you. He said that they didn't have standing and he didn't have subject matter jurisdiction, which meant he should have dismissed the case, which he did. But he went on to decide two other things that were just absolutely outrageous. One, he said the deadline was valid. The deadline is not valid. The deadline was in the preamble, and it's invalid and it's unconstitutional because it violates the 10th Amendment. And because the Article 5, which talks about constitutional amendments, it sends the text out to the states so they can say yes or no to the amendment, so they can ratify or not ratify. Well, the states can only ratify what's in the text. So it wasn't in the text. The preamble is not the text of the amendment. If you look at what the ERA says, it doesn't include a deadline. So it's unconstitutional. It's an unconstitutional nullity from the beginning. Okay, and the other thing is that it's not necessary to take away the OLC opinion if Congress passes the substitute validation resolution. But if the Department of Justice wants to stop fighting against the ERA in the court, they could look at this and agree that the deadline is unconstitutional and tell the archivist just to go ahead and publish it. And so what I've done is I've included in the chat the memo that I wrote so that you can look at it in Adobe PDF and see what I put in it, and that the court in DC did not even have the power to make a decision about the deadline. And he also said something ridiculous, that the archivist had discretion whether or not to publish. Well, that's not true. The law that tells him to publish doesn't give him a choice. It says when the necessary number of states have passed it, ratified it, you need to publish it in the Constitution. Thank you for your time. I appreciate it.
Thank you. That was really excellent. Our next presenter is the group ERA Action. And I just want to check in with the rest of the presenters. We have a request to move Vote Equality USA up to the closer to the top because they have to leave. Would that be okay with everybody? or is better said, is anyone objecting to moving Vote Equality USA to next, per se? Tammy, is that okay with you, Tammy?
I just like to go ahead and go if that's okay. I'm not an attorney or anything, you know. I don't have kind of argument to or rebuttal. I'm just here as a advocate.
And after Tammy, we'll do Vote Equality USA. Okay, Sheila, so please put ERA action next.
You want me to go? Oh. Every time I go to talk, that happens. Anyway, hi, everyone. I'm Tammy Simpkins, and on behalf of myself and my fellow ERA Action co-director, Kathy Kalin, I want to thank you, Kamala and EME, for putting this town hall together. And I want to, really echo the tone that Eileen set about unity. That's what this is all about right now, is unity. We're so close, and we have to be together on this. Now, Kathy does send her regards and regrets. She can't be here with us this evening. She has a family obligation. Her husband's put together a birthday dinner for her. She's got her birthday coming up. So I think, she's with us in spirit for sure. So real quickly, I wanted to tell you all about just a tiny bit about my ERA journey. Started back in 2012 at Ohio University. And that's where I learned about the status of the ERA, that it had not been ratified into the Constitution. And I want to just say quickly, I don't want to cry. I'm not going to dwell on this, but the reason I was at Ohio University is because I was going to work, because my dear husband, Tom, was going to be soon not able to work anymore. And I did lose him last month. I just want to honor him here this evening and let you all know that he supports our cause. He's always been there in the background, and I know he's still there with us. So with that, when I was at the university studying there, I was doing an internship. I interned with Obama, and through Dr. Pam Kalar, who was one of the women's studies professors there out of Kentucky. And then I also had Dr. Kathleen Davies, and that's where I learned about the ERA, and doing research, learned about Carolyn Cook and United for Equality and the 3-state strategy, because before that, I thought it was going to have to be the start over. So, and that's what we all thought at that time. Now, ERA Action formed as a result of the 2013 ERA White House petition, the We the People petition. And that was successful in getting the Obama administration on the record to support the ERA. And it brought ERA advocates together to work. And that White House petition was co-authored by myself and Lou Ann Smith from ERA Now. And then Kathy got involved in it. ERA Action formed along, my mother was one of the co-founders, along with and Heather Welsheimer and Jason Kinnaman here in Chillicothe, Ohio, and then Kathy there in Cincinnati, Ohio. And it also got everybody working together there for a while, especially on social media. We had some really great campaigns going, and from the beginning, the ERA, our mission for ERA Action was to get the ERA ratified in the timeliest manner possible. We thought that was, and still believe that's the 3-state strategy. And we did it with the 2-prong approach, working in the states and on the national level to get the deadline removed in Congress. And we went on the ground, and like I said, on the web. We worked with a lot of groups in the unratified states in Nevada, Illinois, Virginia, Georgia, Arizona, and Washington, D.C. And then, Kamala even came here to Chillicothe we've done a lot of stuff locally as well. And removing the deadline has been one of the major focuses because Ohio is a ratified state. Personally, I'm one of the proudest things I'm proud of myself for with this is the commitment to keep the advocates connected through conference calls. And those all started back with the PDA back in 2013. And then 2017, the call started, and I've been a co-host with the call with Sharon J. Hill and then Helene Du Bois Swanson under the umbrella of Katrina's Dream. And then we have the ERA committee here in Chillicothe, or Chillicothe-Ross League of Women Voters. And we work with Ohio Now and Carolyn Casper, and that's on national as well. And again, with HJ Res 17 passing, and now, it's all in the Senate, that's where our focus is. This aligns with ERA Action, with the ERA Coalition, with Katrina's Dream, the League of Women Voters, and of course Now. And then I wanted to mention this really amazing event we had back in March, on March 23rd, with the collaboration of many people. And the panel of Julie Suk and Susan Bevan, and I didn't write the names down, so I'm going to blank, and I apologize. Steve Anderson. And that was a great event through the league. And I'd like to see a lot of leagues do that. And we're really focused on Rob Portman. We have these calls, and I hope that y'all will join them through Katrina's Dream. And I'm glad that we're going to be united. I look forward to hearing other people's point of view, but in our mind, the goal is to knock down this barrier, and we believe that's in the Senate, and that then we'll see what goes on in the courts, but let's get this barrier knocked down. Thank you.
Thank you, Tammy. Thank you. I'm so sorry to hear about your husband. Thank you for sharing that, and we send you lots of love. Now we will move, we will leapfrog to Liza Mickens of Vote Equality USA. Thank you, Liza, and thank you. I think Katie will also be talking right after you. Is that correct?
Yep, I just need to share my screen. I've got just a few slides to go through really quickly. But thank you so much for having us here today and hosting this. This is so important to have the meeting of the minds, and so we're so happy to be here. It's not letting me share, but as an organization, Vote Equality US emerged out of the group that ratified the ERA in Virginia, and the efforts that happened there to make sure that Virginia was the historic 38th and final state needed for ratification. And those efforts were celebrated last March, actually, on the last weekend, really, of anything happening in the world. So it was great that we were able to celebrate the accomplishments of Virginia, but there is still work to be done. So as an organization, Vote Equality is really about ensuring that people are educated on this issue, and that is something that I've stepped into. I can say that a lot of people my age are not aware of the lack of constitutional gender equality, and generationally there's a large gap, right, between the movement from the 70s and the efforts that stalled there. There's a large educational gap. And education is the foundation of creating change in this country. And so we are making sure that everybody has a seat at the table, but also making sure that the youth are involved in this issue, because there have you know, there have been so many incredible figures, and it's such an honor to be across from them on this panel. But we really have to be the ones that carry the baton on this issue, you know, and we can't let the efforts fail with our generation. And as we've seen, I can share my screen. As we've seen, there has been, let me just go back to the beginning. So sorry. I'm just gonna skip through some of these slides. But essentially, we, like I said, are a nonpartisan grassroots effort. And this was in 2020 when we ratified, and then this was at our celebration right before COVID took over. And so in this past election season, we really wanted to make sure that people recognize the power of their vote and realized that that is a huge factor in making change in this country. We have to have leadership that recognizes the need for gender equality and prioritize gender equality. So in honor of the late Justice Ginsburg, we did a notorious RVG tour throughout the southern states, and even went back in January for Georgia's special election. So really making sure that we are raising the awareness on this issue. We have created efforts to have craftivism activities. So Equality O'Clock was to ensure that our legislators are aware that, you know, the time is now, and the time has been now. And, you know, all of the efforts that have been happening for years and generations, it's really time and past time. And so this, I would be remiss to not mention the incredible team that we have of female leadership. And again, making sure that everybody has a seat at the table. And in that, we have taken on a great team of interns as well, because like I said, we have to be the ones carrying the baton on this issue and making sure that our generation is aware of the lack of constitutional gender equality. And with that, we all recognize, and we're all here today because we realize that the 28th Amendment, the Equal Rights Amendment, is what we need for some real change in this country. And it can't just be a symbolic act to add it to the Constitution. It needs to have action behind it and make sure that all Americans can live up to the creed of justice and liberty for all. And so with that, everybody here knows the facts. We know the stats, and we have all felt the effects of gender inequality at some point in our lives. And as a 23-year-old, I hope that there will be measurable change so I don't continue to feel the effects as I grow up. And I hope that more generations to come don't have to feel the effects of gender inequality. And with that, really, we just have to focus on fixing our Constitution, making sure that the future is equal, and making sure that that equality is all inclusive. So I will turn this over to our director, Katie Hornung, and you can follow all the efforts that we're doing at Vote Equality US. So thank you again for allowing me to be here today and be a part of this meeting of the minds. This is really great.
Thank you. We really enjoyed hearing that, and we really look forward to continuing our work together. Katie, so excited to see you here. Indefatigable, Katie.
Or a little crazy, something. So Vote Equality US, our leadership basically represents the grassroots who delivered each of the last 3 states. In our kind of inner core team, we do have advocates representing each of those last 3 states. A lot of our leadership is from Virginia, since we are right next to DC and we were the very last state. So our group was still really together when we then made the pivot to national. But as usual, we are always focusing on education and outreach. One of the things that we realized here in Virginia was sometimes the answer is not to talk to the politicians. The answer is to talk to your friends and neighbors, and to really drum up support for this issue, and to make sure that everybody understands the gaps and the limitations in our Constitution. To that end, a lot of our actions are focused on voter education and awareness, and trying to build that drumbeat in communities. We currently have, and I'll just run through a couple of things that we're doing this year and into early next year. We currently have an action that we are really hopeful that people will do in their local communities, called Inequality is for the Birds. It's a very family-friendly, gentle outreach. It's something that you can do an art installation at a school, at a library, in your neighborhood. We've gone a little harder in other times and then a little softer in other times, because the reality is everybody needs to hear the message in the way that they can hear the message. And so this particular activity is meant to be fun and family friendly, and that's on our website, which is voteequality.us. We are completing our activity analysis, ranking, we've been at this, I think I've been in charge on some level for about 4 years now. And we have done pretty much every action under the sun that I can think of for activism, including a 24-hour vigil. And, we really have hit the full gamut. So we are ranking our effectiveness versus our use of resources in the hopes that we can then provide some guidance to people who are doing actions in their states, things to skip maybe if you don't have the resources, maybe it isn't enough of a payoff, other things to focus on because the payoff is really worth the effort, or the payoff is huge and it's not that much effort. So that's one of the things that we're kind of finishing up. We will continue supporting state equality efforts. There are some states that are working on state level ERAs, as well as other states that are ratifying the national ERA. We do have a website that is focused on a strong FAQ section so that all the talking points are available to anybody who needs them. So then for this summer, the RVG is probably going to hit the road again and head up to the upper Midwest, where there are some state ERA efforts underway. This spring, we will be announcing a visibility and awareness campaign at a national level. This fall, we'll be hosting a direct action in DC, and next spring, we've got a large event planned in DC. And in 2022, for the elections for voter outreach and education, we do plan to rewrap the notorious RVG with some new graphics and to head out around the country again. So our efforts are, as always, education and outreach. We will work with anybody to get this done. We don't believe in working in silos. We think that anybody and everybody should be at this table together. And to that effort, we recommend, check out our website. And if you need any support or help, we're here to help.
Thank you, Katie. Thank you so much. We look forward to continuing to work with you. And now speaking of state actions that are still in play, I want to introduce ERA North Carolina Alliance's Jimmy Cochran Pratt, who has been at this for quite some time. And I'm really happy to have her here representing North Carolina's coalition. Hi, Jimmy.
Okay, thank you, everyone. Thanks for having us, and thank you, Kemi, for organizing this event. It's great to see so much participation. North Carolina is not ratified in the state level, national level, and we think it's very important to be ratification continue in states, across the nation, even though we have the 38 that we need. We've been able to have a very, very active group with the ERA and C Alliance because of our fantastic lead organizations. And there's nothing that we do that we don't depend on the League of Women Voters North Carolina ERA lead action team. So I say thank you to them. And tonight, I just want to report on what we are doing currently and what we will do what we need to do to get this all done. When the ERA is declared to be the 28th Amendment, the ERA North Carolina Alliance with its 13 lead organizations will mobilize in Raleigh, North Carolina. That's our state capital. As of this publication or my statement today, we don't know when this will happen. And so I'm picking up lots of good information from the speakers, but we expect that with the ratification, with the validation, we'll have about a week to go forward. We want as many equality warriors as possible to assemble at the North Carolina General Assembly. Now that COVID is somewhat behind us, we think we'll be able to meet in person. We plan to have a press conference with the chief bill sponsors in North Carolina. We have wonderful ones, and to publicly call on the North Carolina General Assembly to ratify the ERA now, right now. We are going to be offering talking points made by the GOP for ERA. Thank you, Steve Anderson. Along with additional information in folders will be distributed to all of the Republicans in the North Carolina General Assembly. None of them supported the bill at all. We have every Democrat in the House and the Senate supporting, but no Republicans at all. We have a little small hourglass with a logo. It's time for women's equality to be distributed to the bill sponsors as a thank you. And the plans will be announced in our MailChimp, in our newsletter, on our website within 24 hours of validation of the 38th Amendment. While everyone can't travel to Raleigh, we trust that many of the ERA supporters as possible will join in making North Carolina women's voices heard. We think it'll do great damage to the state when the ERA is verified and validated and North Carolina is not among the states. So it is important that we carry on. Remember, North Carolina waited 51 years before ratifying the 19th Amendment, and we will not wait another 50 years to ratify the ERA. We want in. Another thing that we are doing through our lead organization, social media, website, newsletter, is we continue to ask the U.S. Senate to support the Equal Rights Amendment. We have a priority list of senators, which we are encouraging friends, family, and through social media to contact those senators, especially those in states where it has already been approved, such as Ohio. We think that they should be stepping up to say our state ratified. We back that up. And that's all I have for now, but we are carrying on with full force, and we thank you for giving us this opportunity to report tonight.
Thank you, Jimmy. That was fantastic. And when we send out our post town hall wrap up, we will make sure that all of the organizations, and if you want your emails, will be included so that people can continue to be connected to one another. Our next the next presenter, I'm very excited to say, is a fantastic attorney and a managing partner of the law firm Winston Strawn. And she's here today in her capacity and on behalf of her work of legislative strategy for the ERA Coalition. And I'd like to introduce Linda Coberly. Hi, Linda.
Hi, Cami. Good to see you. Thank you so much for having me and for organizing this event. I'm excited to be part of the conversation and really support the idea that we should all be supporting one another and supporting all the strategies, because all the strategies are important. So you've heard a little bit about the litigation already, and you've heard also about the legislation. And I just want to say a few more words about that. Obviously, we've had some litigation, and we all read the DC District Court opinion with disappointment. And one thing I can tell you is that is not going to be the last word from any court on that subject. In addition to the Equal Means Equal lawsuit, which is going forward, there is going to be more litigation in a year. Just to give a little bit of background on the litigation, the reason the archivist has been important to the litigation for this past year is because of the third clause of the ERA. The third clause provides a 2-year delay period on the effectiveness of the ERA once it becomes part of the Constitution. And it's because of that third part that no one has been able at this point to file a lawsuit trying to enforce the provisions of the Equal Rights Amendment. Those lawsuits will almost certainly be filed, start to be filed in January of 2022, the 2-year anniversary of Virginia's ratification. And at that point, courts, if Congress hasn't yet acted, courts will have to decide whether they agree with the district court in DC or whether they take some other view. In the meantime, my efforts and the efforts of many folks who I know are on this call and not on this call are to push forward the legislation. As all of you know, the House passed the resolution that the same one it passed last year. And as I understand it, the reason the language is the same is because passing the same resolution again enabled the House to do it very quickly without another markup, without another hearing. So because the House had passed that resolution as it stands, the very simple one that simply removes the time limit, that same resolution was put up to the floor again for a vote and it was passed. So for those of you new to this conversation, why is it possible for Congress to remove the time limit at this point? Well, the time limit was put into the joint resolution's preamble, the language at the very beginning of the joint resolution in 1972 that proposed the amendments to the states. And at that time, because the time limit is only in the preamble, it is not part of what the states were voting on to change the provisions of the Constitution. That has two implications. One is it gives rise to an argument that we've seen in the litigation, which is that that time limit is just not effective to change the process for amendments set out in Article 5 of the Constitution. Article 5 says that an amendment becomes valid when ratified by 3/4 of the states. And of course, the ERA has been ratified by 3/4 of the states. So that's the first issue, is whether the time limit is even effective and whether it should be there and whether Congress has the power on its own to change the provision, the requirements for ratification in Article 5. The other issue, though, is by putting the time limit in the preamble to the amendment, Congress reserved for itself the power to change it later. And it did so. Congress has already concluded that it can change a time limit after the fact. And it did so in the late 70s when it passed a resolution by a simple majority to extend the time limit by 3 more years to 1982. So that's what the current legislation is seeking to do. Again, the House passed the same version that it had before it last year, and the Senate is holding that version it's called holding it at the desk, but also is considering its own version and potentially having a hearing later this year. And there are conversations that I've been part of and that others are having, I know, to change the language of the resolution in the way that you heard about earlier on this call. And I think it would be terrific if the language could be changed. It would be better because having a recognition by Congress that you could, that not only is the time limit not there, but the ERA is effective now, that would be terrific if we could get Congress to pass that resolution. Whether we can get that resolution passed or the current resolution passed, I think is a question of politics and a question about which there are lots of opinions, including among our sponsors in the Senate. And so that's where the conversation needs to happen. My view is that even if it is the current resolution that's passed, that would still be helpful for the litigation. Because at the end of the day, we already have a recognition by Congress that a state, once it ratifies, can't rescind its ratification. We have that recognition because the state recognized the 14th Amendment as being, Congress recognized the 14th Amendment as being fully ratified at a time when 2 of the necessary states had voted to withdraw a prior ratification. So we already have that judgment made by Congress in the context of the 14th Amendment. And we can argue that that same principle will apply here. So I fully support the legislative strategy. There's been a lot of conversations happening with legislators, and I encourage everybody on this call to call your Congress people to make sure that your senators are co-sponsoring the bill. I've been involved in some conversations with Republicans as we're trying to get to 60 votes. Obviously, if we can't get to 60 votes, then we're going to have a conversation about the F word, which is a conversation I expect is going to happen in any event because of all of the different important legislative agenda items that the Biden administration has right now. One thing I want to say about the Biden administration, at this point, we still don't have a confirmed head of the Office of Legal Counsel, and it was the OLC that issued that opinion. So I don't think we should be discouraged at this point by the fact that the Biden administration hasn't done more. The fact that that OLC memo exists is something that is probably going to hold back the administration from taking any action until it gets a confirmed head of the OLC in place and revisits that issue. And so let's not lose hope that the Biden administration is going to take action on this issue. But I think job one, I've said this before, job one of the Biden administration is to let the Department of Justice do its business. Because one thing we saw during the Trump administration is the incredible damage that can be done to our system of justice when the White House attempts to control the Department of Justice. So let's not be surprised about the fact that the Biden administration hasn't taken decisive action on this. I think once we get the OLC head confirmed and in place, and that is happening as we speak, there will be some action on this subject. And in the meantime, let's not lose hope, because I do expect strong support from the Biden administration when the time is right. Thank you again, Cami, for having me and for hosting this conversation.
That's very exciting. I feel some positive optimism there. Thank you, Linda. Thank you for coming, and we'll continue to converse. If you can stick around for the Q&A, or even drop off and come back if you have to for the Q&A, I'm sure there are going to be a lot of cues for you to A. So
great. Thank you.
And now I have the great pleasure of introducing Wendy Murphy, who is the legal counsel for Equal Means Equal. And she's going to speak about what we've been up to in the courts and what's going on with our lawsuit. And I hope she retains some of the optimism of Ms.
Well,
thank you, Wendy. Hi, Wendy.
I'm just getting a glimpse of my hair. Cam was very clear. We should look nice for these things. I'm usually in a ponytail. Thank you so much. I'm really enjoying listening to everybody's perspective, and excited to hear calls of unity. I think because this has been Sexual Assault Awareness Month and Women's History Month, I've been giving so many talks all over the country, and I think I've said the word unity and solidarity about 8,000 times. It is frustrating, to say the least, to experience the struggle of being divided. And, you know, it's not news, nor is it a new strategy, that when women come together and do rise up and unite and start to fight for important things like equality, that we become divided by external forces, and it's extremely hard to fight back. So I'm glad that we are all talking about resisting that really ugly strategy that has hurt us in this cause and so many other causes over the years. I guess I'm going to touch on a few points. I'm going to try not to be redundant, but I'm going to touch on a few points. I have some slides. I'm not going to share them because they're not 100% everything I'd like to say, but I'm just going to touch on a few ideas. Nah, forget the slides. I'll just read from my notes. First and foremost, to repeat the point about the deadline not being valid, I think we all know the argument, but I want to be clear about the importance behind the idea that the deadline is not valid because it was placed in the preamble to the ERA. The reason that's important is because Article 5 gave both the national government and the state governments equal powers under Article 5. In other words, when Article 5 was written to tell us how the Constitution is to be amended, it was written to give equal power to the federal government and to the state governments. And all the comments at that time by the framers said the states have to have equal power. They can't be controlled by Congress when it comes to making decisions about how our Constitution is amended. And to that end, the states being the form of government that does the ratifying and the Congress being the form of government that does the proposing, you have to make sure they have equal power. Well, if Congress can put a time limit on how long the states have to ratify, and in a way that, because it's in the preamble, the states don't have a chance to vote on or approve or disapprove, you have just given Trump power, if you will, to Congress. If Congress can dictate how long states have to ratify and not even give them the chance to decide whether they agree that their rights should be restricted by a time limit, then you've just given total power, total mandatory power to the national government, to the detriment of the states. And remember, people speak through the states. When the states' rights are restricted, I know states' rights aren't always a conservative or liberal idea, but in this context, when you tie the hands of the states in terms of their power to participate as equals in the amendatory process, you're tying the hands of the people. And that's why it's such an important and such a powerful argument for us. The idea that this is not a constitutionally valid time limit. It's because we care about making sure that the states have an equal voice in deciding whether our Constitution is to be amended. And the funny thing is, what Congress has done by imposing a time limit on the ERA is really done an end run around Article 5. In other words, Congress has basically changed Article 5 without complying with Article 5 by telling the states that Congress will tell them how much time they have, and the states will have no say about it. That's changing the very careful balance of powers that was struck in Article 5. And Congress can't do that under Article 5 without changing Article 5. So Congress can put whatever it wants in the text of an amendment so that the states can decide how they feel about it, but they can't put it external to the amendment itself. That's the problem. And we feel very strongly about the strength of this argument. So why is that really important to me today to emphasize? Because the strategy of going to Congress, the legislation strategy, if you will, undermines our argument. When you go to Congress and say, we want you to remove the deadline, you're basically saying it's because we think the deadline is valid. We wouldn't need to remove it if it wasn't valid. Courts remove invalid, unconstitutional deadlines. You don't need Congress to remove them. The courts remove them. They remove them by striking them as unconstitutional. So just by going to Congress, we undermined our own litigation strategy by creating this idea that they were both valid and invalid at the same time, or at least we didn't know what we really felt, or we had a lack of confidence in our legal strategy because we were telling Congress the deadline was valid and we're telling the courts the deadline was not valid. It's a problem. And let me be clear about my feelings about whether, regardless of that issue, can Congress retroactively remove a deadline that doesn't exist? Absolutely not. I know people disagree. I'm going to tell you why I think it's obvious that they cannot retroactively remove a deadline. It's as simple as the fact that the deadline, if it is valid, doesn't exist anymore because it expired. And you cannot retroactively go fix something that doesn't exist anymore. And there's all sorts of other laws about how a Congress today can't be bound by a Congress from the past and vice versa. But the real critical point here is that if the deadline expired, meaning if it's valid and we want to remove it, so we have to presume it's valid, it's not removable because it no longer exists. Now, I use this as a kind of common sense argument, right? But it's also true that the scholars, the constitutional scholars in this country, don't believe that Congress can retroactively remove the deadline. They just don't. There's not a single constitutional scholar in this country that agrees that Congress can retroactively remove the deadline. In fact, to the contrary, in 1978, many constitutional scholars testified before Congress in support of Congress extending the original 7-year ERA deadline to 10 years. Lots of constitutional scholars testified, and at that time they said, we believe you, Congress, have the power to extend this deadline, but you have to do it before it expires. If you wait until it expires in 1979, so they were testifying in 1978 before it expired. And they said, if you wait until it expires in 1979, you will forever lose your power to affect this deadline. That was what the constitutional scholars said in 1978. So it's not me. I'm not a constitutional scholar. And I can only tell you that I know of no, and I've spoken to many, I know of no constitutional scholar that agrees Congress can retroactively remove this deadline. Some people who are scholars disagree with me, but they're not constitutional scholars. And that's very important. It's not just positive, it's just important. So the second question is, well, what if we changed the resolution to remove the deadline to just be, which is what Arlene was suggesting earlier, to just be a declaration from Congress that the ERA is valid? I'm hesitant to say, I'm hesitant to say this is impossible, because I would, if it worked, I'd be delighted. I don't care how we get the damn ERA. I'll take it from any branch of government through any mechanism. I really will. But I think we have to be smart about how we spend our time and resources. And I don't think that even if Congress agreed, which I don't believe they will, if they agreed to pass a resolution just declaring the ERA valid, which is sort of what they did with the 27th Amendment. But even if they did that, that issue would land in the courts, because though it would be framed as a political issue, non-justiciable in the courts, meaning the courts would have no business addressing the question of whether Congress has that power, somebody would file something in the courts, and the courts would absolutely seize the opportunity to say, the way Congress did this is not a political question. It is a justiciable issue, because what Congress just did is an end run around Article 5, and that's a constitutional issue for the courts to decide. That's my thoughts about that issue. I just don't see it happening. Now, what Congress does have the power to do, and this is what Arlene was referencing in terms of what we know thus far about case law. There's a case from 1939 called Coleman. Coleman does speak pretty generously about the power of Congress to manage procedural aspects of the amendatory process. And it's a long decision, it's an interesting decision, but Coleman is a very divided court. A plurality decision, meaning there was no unanimity among the justices about how they felt about how much power Congress ought to have. They really weren't on the same page. And in the four-judge, I believe it was the four-judge opinion, the plurality opinion, the court said Congress does have the ability to decide, to vote, to decide whether an amendment with no deadline at all has lingered too long from its proposal by Congress to the date the last state ratifies, has too much time passed, or is the time reasonable in light of the circumstances? So for amendments with no built-in deadline, Congress has the power to decide whether the passage of time is reasonable. That is what that court said about what Congress had the power to do with regard to deadlines. There's a concurring opinion that is not considered settled law by any stretch, where a few of the justices opined that Congress ought to have what's called plenary power to decide all sorts of things about how amendments are adopted. That is not widely accepted as the current state of the law. And even if it were, I don't think for a minute that the courts would defer to Congress doing anything it wanted to an amendment, not if the courts felt that it was unconstitutional, because as we all know, the courts have the final say on what the Constitution means and whether it has been complied with. So I don't think that Congress has a real role to play here. I just don't. I feel very strongly that the courts can and will take any opportunity they can to speak to this issue and will pass judgment on whatever constitutional questions land before them, including not only in our case in Massachusetts. I believe that the DC case is not going to be appealed, which is unfortunate, because that's going to leave a really poor decision, and I think easily challenged decision in place. So I'm not sure why that case isn't being appealed. It should be appealed. There's lots of good stuff in there to challenge and to complain about. But I think the bottom line is, as many of us, and Linda said, we're already planning our lawsuits for January of 2022, just like we were planning our lawsuits to enforce the ERA years before the archivist refused to publish. The other thing I want to say about the archivist, by the way, just to kind of hammer home how angry women have a right to be about the fact that the archivist refused to publish. As you heard Cam say at the outset, he promised us in 2012, this particular archivist, not just another person in the position, this particular archivist, David Ferrero, promised us in 2012 that if we went and got the other 3 states, that he would publish. And he was clear in that same letter that he issued that the rescissions would be disregarded because they're not valid. Everybody seems to agree about that. And yet when we got the last state to ratify, this archivist changed his mind. You know, it was a bait and switch. I mean, it was sort of a Wizard of Oz moment. We got you the broomstick and you promised, and what do you mean you're not going to publish? Now, of course, he did it in deference to the DOJ's letter declaring the ERA dead, but he wasn't supposed to do that because the statute that dictates his duties makes clear he has no discretion whatsoever to question the constitutionality of an amendment. His job is simply to publish. If people want to go have a fight in the courts after publication, they can. But he is not in a position to make any kind of assessments about the legality of anything. He's just a librarian. Put the stamp on the document, put it in the law books.
And on that line, we're going to have to wrap you, Wendy, because you've gone over your time.
Oh, I apologize. I wasn't keeping track. Can I just end with one sentence
about for you?
I'm sorry?
You've gone over your time. We've got to move.
All right. Sorry. I wish you had given me a warning because I was going to say something important, but that's all right.
Tila told you 3 times.
I didn't hear anything.
Okay, finish your thought.
I sent you message, Wendy.
I'm so sorry.
On your screen. Okay, it's okay.
Finish your thought.
The only thing I was going to say is, so the archivist says, I'm going to defer to the DOJ. And some people say that's fine. He has the power to do that, or the right to do that. He actually doesn't. But even more importantly, when he published the 27th Amendment, that was in the face of a Supreme Court decision that had already been decided in 1921, telling the archivist and all of us that the 27th Amendment was too old in 1921 to publish. So if he could disregard the Supreme Court of the United States and publish the 27th Amendment, can't he disregard a letter from the DOJ and do his job? Women deserve to be angry about being treated differently than a damn 27th Amendment.
Right on. And on that note, thank you, Wendy. On that note, I'm very excited to introduce Alice Cohan from the Feminist Majority. I'm really happy that she's here today. Ellie couldn't be here, but I hope you tell Ellie that we showed her in the movie at the beginning, and we're very happy to have you, Alice. Please unmute yourself. I think you went ahead and muted yourself again, so just tap it once. Still mute. Tila, can you ask Alice to unmute?
Okay, now you can hear me.
There you are. Okay, perfect.
Hi, everybody. For those of you that don't know me, I've been active on the ERA since the mid-1970s as a volunteer. Later, I traveled the country as NOW's only ERA field organizer. That's how little we were at the time. Then became the political director for NOW, and for the last almost 25 years, I've been the political director of the Feminist Majority. My specialty is mass demonstrations. That's just a little bit so you'll know who I am. We've ratified 38 states. It's taken 49 years since Congress passed the ERA. Almost 100 years since Alice Paul wrote the amendment. The Pew report says that 8 out of 10 people support the ERA being added to the Constitution. 80%. Isn't that amazing? Well, as I look around the Zoom and the list of participants, I see lots of old friends from all over, and I see many new friends too. It reminds me of one of my favorite stories. Back when the Equal Rights Amendment was pending in Congress, a group went down to be part of a 24-hour vigil in front of the Senate, pushing for ratification for it to be confirmed out of the Senate. And by the time they finished their shift, it was quite late, and they were supposed to be staying at the Women's Party headquarters, so which still stands right next door to the new Senate office building. And they made their way there. It was all dark, but they decided, well, they knocked on the door ever so lightly. And in a few minutes, the door creaked open and a little voice said, "Are you from now?" And they said yes, and the door flung open. And there was this little old woman in her dressing gown welcoming our people into the hallway. You should, if you're ever in DC, you should go and visit. It's a living museum. There's statues of leading suffragists. At the end of the hall stands a statue of Joan of Arc. And this little woman, who, by the way, was Alice Paul, because at that time she was still living and working for her dream of the Equal Rights Amendment, and working out of that headquarters and living there. And she picked up a bell and she started ringing the bell and she shouted, "They've come, they've come, they've come." And sure enough, doors opened upstairs and women came rushing out in their night clothes to welcome our friends. Well, one of my friends was really embarrassed and said, "We can't stay here. We should just say hello and go to somewhere else." And the other friend said, "Hey, listen, if you had been waiting 50 years for reinforcements, you'd be pretty excited too." And I tell that story because every one of us on this call is a reinforcement. Whether we've been in this campaign for 50 years or 5 years or 5 minutes, we're all critical to the team and to the effort. And nobody can take that away from us. The feminist majority believes in a multiplicity of strategies and tactics. If there's something we can do that might work, we're ready to try it. We don't criticize publicly other groups' strategies, and especially we don't criticize other women in the movement, because we're all working in different ways towards the same goal of equality. And who knows what's going to work, what's going to be the final thing that will knock it over and put us through and become part of the Constitution. So we're going to do the combination of marches and rallies and phone banks and emails and Zooms. How many Zooms have you been on? And lobbying and every kind of visible activity that we can do to keep the visibility up and the push and the strive for the Equal Rights Amendment. Currently, the feminist majority has 3 major efforts. Number 1 is our electoral strategy. We believe that if somebody's in a congressional or state legislative seat and they're not for equality, they shouldn't be in that seat. And we're trying to replace them with feminist women with a special focus on women of color. To replace them, how did we get it through Congress in the beginning? Well, finally, Elizabeth Holtzman, a young woman at the time, lawyer in New York, challenged the guy that was the chair of the committee that was holding up the ERA. So the electoral strategy we think is critical. And we've worked in many states around the country, endorsing feminist candidates, in giving contributions, doing independent expenditures, whatever strategy will work. Number two, our second strategy that we're working on is we're cooperating with the ERA Coalition. We support them and work with them. And I see many of you that I know from the bi-weekly calls on this call. We're working to get 60 votes strategy to end the deadline. And they now have over 200 groups as part of the coalition. The third strategy the feminist majority has launched is ending the filibuster. We can save the Senate that way. You realize that with the filibuster right now, we need 60 votes for passage to end the deadline. If without the filibuster, we only need 51 votes. So we've launched an ERA campaign, and we're asking people in the grassroots to write to your senators to urge them to support the filibuster, support ending the filibuster. We've created a mini site, erayes2021.org. It's a new website. If you go to that, you'll see some famous people and celebrities with videos. The other advantage of working on ending the filibuster is that we have a larger coalition, because we're coalescing with people working on voting rights, on VOW, on gun violence, justice in policing, the environment, and the list goes on. If we can break through that filibuster, all these critical issues, including the ERA
2
deadline,
minutes, Alice.
can go through. Did
2
you say
minutes.
2 minutes?
Yeah.
Okay. They say that we can't win. They say that all the time. They said it during the first extension drive in 1978. And our major roadblock there was the majority leader, Robert Byrd from West Virginia. He wouldn't calendar or schedule the vote on the ERA extension in the Senate. And we knew that he would only see West Virginians. So we organized delegations of West Virginians, doctors, nurses, lawyers, teachers, caregivers, homemakers, volunteers of different groups to come up and visit with him here in Washington and in West Virginia in his district offices. And we culminated with a 6,000 person rally in the Upper Senate Park, all from West Virginia. And he let the scheduling go forward, and we passed the extension. He came to our celebration and he said, I see America when I look out at you, and I will never forget you. Let's make sure that they all remember us and they give us what we deserve. Equality of rights under the law shall not be denied or abridged by any state. And that's what we're all fighting for. And every way we can do it, we come together unified for the goal of equality. Thank you very much.
Thank you, Alice. We really appreciate that. And we loved hearing those important stories. It's so important for us to, as somebody also said, not to be doomed to repeat the same errors that we've made in the past. And we greatly appreciate your participation. And it's so interesting because we're going from veteran OG feminist ERA activists to the newest kids on the block. I'd like to introduce Generation Ratifies Rosie Couture as our next speaker. Hi, Rosie.
Hey, and I'm sorry in advance. I am a teenager living in my parents' house with really noisy siblings, so I'm sorry for the background noise that you may hear. I have a little brother. But yes, Alice, you are such a tough act to follow, but I'm going to try my best. Hey everyone, my name is Rosie. Thank you so much to Equal Means Equal for putting this on and for all the incredible groups and activists that are sharing this space right now. I'm here speaking on behalf of Generation Ratify, which is the youth-led arm to enshrine gender equality into our Constitution. And we are all about, bringing young people into this fight and just ensuring that our voices and our perspectives are being heard by our legislators, and to also, really push the conversation to be disruptors, and just make sure that future generations are here to carry on the torch once we have the ERA in our Constitution, to really fight for all that it can be. And we are a chapter-based organization. We have over 50 chapters on both the local and the state level that are bringing this mission and fighting in their communities. And given that we are young people, I think that we have a really unique voice in this process. In terms of our strategy, we are not, as young people, we do not have a lot of access to lawyers. We do not have these great relationships with a lot of legislators. But what we do have is people power. We are really focused on building our grassroots power and presence and really building our on the ground organizing game. And I think that this, is just as powerful, if not more powerful, than having those longstanding connections. And so our strategy moving forward is really to expand and strengthen our movement on the ground through both legislative advocacy and on the ground organizing. We are going really hard to remove the deadline on the ratification of the Equal Rights Amendment in Congress, pushing for SJ Res 1. We have connected thousands of young people to their legislators, both through bite-sized actions. We have this form that people can fill out and it automatically sends an email to their senators. And we also sometimes will host just Zoom calls like this, where we have 50 young people just calling into Lindsey Graham's office, telling him to support the ERA. And what I think is the most important thing we've been doing is we have organized over 50 meetings with young people and staffers of legislative offices to have lobbying meetings, all virtually on Zoom, which I think one thing that's so awesome about this pandemic is that virtual Zoom meetings are a thing, or virtual lobbying meetings. Yes, and I also want to second what Alice was saying about the filibuster. Right now, we are working for 60 votes in the Senate. However, we could only need 51 if we abolish the filibuster. So I think while we are working to, gain 60 votes and gain bipartisan support, we can be doing a lot to just also push for abolishing the filibuster entirely. And that also, lets us pass other legislation that is super critical to our fight for a feminist future. Yeah, and like Alice was also saying, on the ground organizing, mass demonstrations, protests, that is really what Generation Ratify is shifting our focus over, in addition to, the virtual lobbying and efforts we have to mobilize young people. Right after HJ Res 17 passed the House, I was in front of Mitch McConnell's house with 15 other young people. We were doing chalk outside of his house. We were playing music. We were having a fun time. And we were engaging other people that were in that space and engaging our community. Having these protests and direct actions is a really great way to mobilize people, bring people together, and, raise a lot of hell and, call out our politicians that aren't representing the will of the people and that aren't fighting for our equality. So I love all the conversation that we have been talking about in regards to, really being on the ground and building public pressure that way. Also, sorry, I have my notes here because I have a lot of thoughts. Yes, so really focusing on just building up a grassroots presence and making all that we're doing super accessible so that a lot of people can join into what we are doing. Generation Ratify strongly believes that we should be pursuing all routes to ratification that we can. So we believe in, removing the deadline in Congress. We also partnered up with Free Speech for the People to urge Merrick Garland to instruct the Department of Justice to rescind the January 6, 2020 opinion that is stopping the National Archivist from certifying the ERA. I see my 2 minutes. I'm going to try and go faster. We also filed an amicus brief in support of the Attorney Generals and suing the National Archivist. And we are, ready to engage in electoral organizing again, if that's what it comes down to. We made 1.07 million voter contacts last year. And okay, I know I'm coming up on time. One thing that I want to make sure I get out is I understand the need to appeal to a wide audience and gain bipartisan support and, kind of meet people where they are at. With that said, I think it's important that we don't lose sight of all the communities and issues that we're fighting for. I think it's easy to kind of push things under the rug to appeal to people that are not comfortable with our equality. I think like talking about queer liberation and how the ERA fights for all genders and talking about that, how the ERA is about abortion. I think it's really important that we're not swiping those issues under the rug, because then I don't think the Equal Rights Amendment is going to fight for all the communities that it can fight for. And yes, okay, I think I'm out of time. But thank you everyone so much. I'll go ahead and drop my email in the chat. I would love to connect with everyone on this call and doing some awesome intergenerational organizing.
Hey, Rosie, will you stick around for the Q&A? Because I can tell people really are going to have a lot of questions for you.
Yes, I absolutely can.
Okay, great. Thank you so much. And if there are any other things that you want to talk about, we can pick them up in the Q&A. I just want to get everybody through. Our next group is Katrina's Dream. I met Helene de Boisier now, gosh, it's almost 15 years ago, when she walked across the entire United States to protest the lack of ERA. And she really is, she walks the walk, baby. Let's give it up for Helene de Boisier of Katrina's Dream.
Well, thank you, Kamala. I don't know, can you hear me? Can you hear me?
Yes,
okay,
we can
good.
hear you. Sheila's going to spotlight you momentarily.
You know, I'm going to be a little tangential here for a moment. I know that you have a team member in India, and I have some very good friends in India as well that I work with as part of our international branch. So because women are hard hit everywhere with COVID-19, I just was hoping we could all just take a moment to send loving thoughts and directions to our brothers and sisters in India who are hard hit at this moment. So just a moment.
I mean, that's beautiful. Even Tila herself and her family have it. So thank you very much. That's really nice.
Yeah, so having said that, I want to thank you for putting this together. It is courageous. Often when one is passionate and outspoken, the way society has constructed itself at this present point in time, we are labeled irrational, argumentative, and so on and so forth, for simply speaking our viewpoint of things. So I want to thank you for always having been an outspoken person as well, Kamala. And I want to thank everyone who is on this particular call, for each year is truly also a passionate, outspoken person championing equality for all. So now that we've done the typical thank yous, yaddy yaddy, the New Yorker has got to come out and say, yo, okay, I'm sorry here, but I have, from the time I have started working on what I call a project, and in India I was corrected by a bishop there, they say, no, projects are things that come to an end. This is a scheme. So sometimes I use words here that have different connotations in the American understanding, and even different than in English. But in the scheme of things here, and the programs and goals we all here, I think, are one and the same. I'm pretty sure that everyone here wants to see women empowered. I'm pretty sure that everyone here wants the Equal Rights Amendment. And I think Wendy stated it best, Wendy Murphy, that is, earlier, in that however it gets done, I'll be happy when it's there. So I am particularly very focused. I have embraced the three-state strategy for a number of years. My tactic and approach is calling upon Congress. I am a member of the legal community, but I don't have letters after my last name, nor do I sit in the ivory tower. And I can't speculate one way or another with 100% accuracy. And I think the lawsuits might be a bit premature, but then going back to the attorney for ERA Coalition, there is no ifs, ands, or buts. Come January, the 2-year time frame of the third portion of the Equal Rights Amendment has expired, if you want to look at it from that point of view. So I am proceeding singly on one area. I'm lining up meetings with both senators at the same time because I felt, and I still do feel, it's rather restrictive to be asked for to go the Noah's Ark approach, bringing one on by one on. I think that is, I understand the bigger picture, but I really want to hurry up and get this done. But folks are invited to attend our Wednesday program. It is designed in the following format, and it was with the concept that many of us would have, having given birth to a great cause, that we would need a support group afterward, and agencies and departments would have to come together. So the program is designed with a meditation, introductions for those who are comfortable, because sometimes you don't always want to speak up. You just want to listen in and figure out where you stand. And then we come up with strategies and tactics. So having said that, our only focus, and I support all efforts going forward. How much I can participate in them is limited to the scope of our abilities to do some things. And I'll give a little tidbit here so you can understand the parameters and limitations that I have as an organization with a truly international presence. And I was in India in 2015. Greenpeace lost their charitable status, as did Ford, that is President Ford, Ford Foundation, and a number of other American organizations and international organizations for being outspoken against the political officials. And it was deemed by folks that if you had an organization that called out political parties or officials, that you were not going to be welcome. So although we have always been a nonpartisan, I really don't like calling out officials. I do like holding them accountable. So that's what I'm doing by setting up meetings every Friday, asking for judiciary hearings, as well as staffers to attend, covering both bases with 2 senators at a time, using what they're calling the Noah's Ark approach with my own twist, which is focusing on particular members of faith-based community, because we're a faith-based organization. Another part of my target list is focusing on women senators. And then finally, have a great day, and thank you very much, Kamala.
Thank you, dear Helene. Thank you, as always, for your commitment to the cause and for all your hard work. I want to introduce Feminists in Struggle next. I'd like to introduce Carol from Feminists in Struggle next. Carol, are you with us? There you are.
Hi there.
Hi.
Oh, wow. Yeah, hi, everyone. Yes, I'm representing our organization, Feminists in Struggle,
And
Can you
we are a,
tilt the lid of your laptop down just a hair so we can see your whole pretty face?
well,
Even
okay.
a bit more, a hair more. It's the filmmaker.
So anyway, yeah, we are a radical feminist organization, and we're working for women's sex-based rights. And we have a number of things that we're working on, the ERA being one of them. We also want to see CDAW get ratified finally by this country, which is also something that hasn't been ratified. Although President Carter did sign it, it wasn't ratified by the Congress. So that's another issue, as well as you know, we want to see equal pay for equal work. We want to see an end to male violence. We want to see an end to prostitution and pornography. We want to see the Nordic model be put into place. We're fighting for reproductive rights and against male supremacy and white supremacy. All of those things are in our principles, but the ERA is really, really important to us. There are a number of us who are second wave feminists who marched for the ERA back in the 70s and early 80s. And we are very, very devoted and determined to see the ERA finally be written into the Constitution. We've been waiting, as others have pointed out, almost a century since the Lucretia Mott Amendment, and almost a half a century since the ERA was in its final form was passed in 1972. So we've been doing a project that entails writing emails to the White House, since they still don't have their switchboard operational, and the White House comment line is still shut down. So we've been writing emails to them, writing postcards on a daily basis. We've been calling the female senators, making sure that they are putting pressure on the Biden White House to remove the Barr memo and to direct the archivist to publish the Equal Rights Amendment, as it was ratified, as we all know, in January of last year by the 38th state. And we also have been active on social media, tweeting all of this out. So as I was saying, we have a number of things we're working on, but this is one of our big actions at this moment. And we totally support equal means equal. And in fact, some of us are Greens. I showed the film in 2016 to one of the Green Party General Assemblies, and when Ann Monash and I made a presentation on women's sex-based rights. So all of the advances that we've made as women have been on the basis of sex. So the ERA is written in very clear language about, you know, the fact that it's based on that any kind of discrimination will be not tolerated or by any state or by the U.S. based on any kind of discrimination because of sex. So we're fully in support of everything that EME is doing, and we've had them we do our feminist forums about monthly or every other month, and we had Equal Means Equal at one of our feminist forums a couple of times, actually, and they did a wonderful job, and we want to thank them for that. So I think that's about all I want to
just, move on so that other people have as much time as they need. And I want to really thank all of you for all of your contributions and your work towards the ERA. Thank you.
Thank you, Carol. Thank you so much. And it's a pleasure to be connected. Thanks to Anne. And we are going to now introduce the organization that was my original fiscal sponsor when I started the ERA Education Project back in 2009. And that is Donna Lent from the National Women's Political Caucus. Hi, Donna.
Hi, Cami. Hi, everyone. I'm Donna Lent, as Cami just said. I'm president of the National Women's Political Caucus. And Cami, thank you so much for including NWPC in this town hall. Really appreciate it. So the NWPC, the National Women's Political Caucus, is the oldest grassroots multi-partisan organization dedicated to recruiting, training, and electing pro-choice women to our public office. And through our coalition to appoint women, recommend to the Biden-Harris administration the most qualified women to fill the nearly 5,000 positions available in this new administration. And if you're interested in public service and serving in the Biden-Harris administration, please visit our website at www.appointwomen.org. So the National Women's Political Caucus has members across 43 states, and our state and local chapters are actively involved in not only putting pressure on elected officials to support the ERA, they work at the state and local level to elect feminist women to office. That really is our mission: recruit, train, and elect women. And our National Political Planning Committee, led by our Vice President for Political Planning, Paula Wilmarth, requires that each candidate seeking an endorsement of the National Women's Political Caucus commit to supporting the Equal Rights Amendment. The National Women's Political Caucus is also a lead organization of the ERA Coalition and a very early supporter, as Cami just relayed, of Equal Means Equal and Kamala Lopez. And in fact, we were your first fiscal sponsor. And I was thinking it was 2012, but you're saying 2009. We go back together a long time, Cami.
Yes.
So I want to thank everybody for participating, and to all the warrior activists who have worked so hard for the ERA, and to Equal Means Equal for putting this town hall together. We wanted to be represented today, to know that we are all in this fight together. We've been working very hard, along with so many others of you that are here today, and then others that aren't here today. This has been really a long haul. We also were a party to the DC lawsuit, and Linda Cobley also represented the National Women's Political Caucus in that. And I was really happy to hear what she had to say today, because I think that it made clear why some things haven't happened, where we can go from here. And, although we all may sometimes take a different path, we all have the same goal in front of us, and that is to finally pass an Equal Rights Amendment. I know we're running out of time, Emmy, so I'm just trying to be mindful of that so you don't feel a lot of pressure.
Thank you, Donna. Thank you very much. I'm sure you can answer questions too. We have two final organizations. One is my dear friend Sandy Ostrike from Pass ERA. Sandy, I'm going to ask you to speak for a shorter period of time, just because I know that now has been waiting a really long time, and we're late. So unmute yourself, Sandy. Unmute yourself. You're muted. You're still muted.
I think those are the most words we've heard over Zoom. Unmute yourself, right? Through all this pandemic.
Yeah, Tila, can you ask Sandy to unmute herself as the host and then it'll pop up for her?
I'm asking her.
Do you see a little box that says click unmute? Well, then we'll come back to you, Sandy, and we'll come back to you either during Q&A or when after now. So without further ado and with great gratitude, I want to welcome the National Organization for Women's president, new president, who I'm thrilled to meet, Christine Nunes. Hi.
Good evening, everyone. Thank you so much, Kamala, for having us. As you said, my name is Christine Nunes, and I'm the new president for the National Organization for Women. I want to first thank you for inviting us to be a part of this wonderful town hall discussing the Equal Rights Amendment and Equal Means Equal. This is just such a great event. As we've all been talking about, this has been an ongoing fight to get Equal Rights Amendment passed and part of our Constitution, and now has been part of this fight over the course of our 55 years of history. And so we're super excited to be included in this event. Now it's coming upon its 55 years as one of the oldest feminist membership organizations, grassroots membership organizations, and we're super excited to be included with so many wonderful coalition partners, organizations who have been in this fight for so long. And this is just such a wonderful unifying event where we're seeing everyone, we're all here for the same cause, right? And that is to, one, see the ERA finally be part of the Constitution, to see women finally be deserved to be treated equal and be part and protected under the law. And we know that when we come together collectively with purpose and intention, we can accomplish anything. We've seen this throughout our history. We are continuing fighting throughout our history, and now looks forward to continuing to work in collaboration and partnership with all of you. We've been doing the work with our grassroots membership, with our ERA committee, with our leaders, and all in coalition partnership. So we're excited. I just wanted to stop by and say hi because my wonderful and now's wonderful Vice President Bear Atwood is going to come to you with some great nuggets of information about the work that Now's been doing. So it is just my pleasure to bring her on. She's been a wonderful civil rights and feminist activist for decades. So I'm sure she's going to enlighten you with some great information. And I just thank you for being a part. We look forward to continuing to working this in collaboration and partnership with all of you. Thank you for this time.
Thank you. And welcome, Ms. Atwood.
Thank you, Christian, and good afternoon, everyone. I really appreciate now being part of this, and I want to thank Equal Means Equal for hosting this ERA Town Hall today. It's been really interesting to hear the presentations this afternoon, and I appreciate the great information. Now is a multifaceted organization. We take an intersectional lens when we work on advancing the feminist causes. We have 6 core issues: LGBTQIA+ rights, ending violence against women, reproductive justice, ending racism, economic justice, and of course the ERA. We have a long time commitment to the ERA, and I'll tell you, I've been there for much of Now's history. I think my parents were afraid I would fail law school. I was so immersed in the ERA extension as an activist Now member. You saw a lot of Now's history in the clip we saw from Equal Means Equal and heard some from Alice, but I wanted to talk to you a little bit about our recent history with the ERA and the 3-state strategy. In 2017, the Nevada legislature, which had strong representation of women legislators in key positions, moved a ratification measure under the leadership of Now member State Senator Pat Spearman, and with the lobbying efforts of Nevada Now and their allies. Both houses of the legislature approved the ratification. This action was followed in 2018 in Illinois, where a strong group of NOW activists and allies had been working with the legislature for many years. And I will say the ERA ratification was all the more impressive as Illinois requires a 3/5 vote in each chamber for constitutional amendments. In 2019, NOW and allies forged ahead with a strategic plan to elect new members who were ERA supporters to the Virginia General Assembly. The Virginia Senate had already approved of the ERA ratification several times in recent years, so activists believed there was an excellent opportunity for success. The election turned the Virginia legislature to Democratic control, and it was truly an exciting and historic event when the House of Delegates passed legislation and became the final state to ratify the ERA. And now activists were there through that whole process and there to watch it happen that day. Now has continued to work on the ERA, and we will continue to work on the ERA. I like the approach that everyone is taking today, saying all roads can lead to equality. We have this spring been hosting a series called the 100 Days of Feminist Agenda Listening Series, intended to amplify the voices of women of color in the fights for NOW's 6 core issues. And we had an amazing panel come on to talk about constitutional equality. It was an incredible conversation that left people inspired to take action, which was the goal of our listening series, to amplify the voices and then to take action. We have an extremely active ERA board committee at NOW. Perhaps you noticed representatives wearing ERA masks the day of the vote to remove the deadline in the House. Our committee designed, and one of our members sewed masks to send to the president, vice president, senators, and representatives, and they arrived just in time for many House members to wear them to vote to remove the deadline. So in case you missed the picture, we have the masks look like this, and they looked wonderful in the pictures. The ERA committee has delivered a petition to the White House asking the president's support for the ERA, and they have postcards on their website you can download and print. Their website is at Nevada Now's website, so it's just nevadanow.org. We've been following the legal cases on the ERA closely, and after the district court decision in the case brought by the 3 ratifying states' attorneys general, we realized that that court at least left open the door for Congress to remove the deadline. So we've been very actively focusing on our activists lobbying their senators to support removing the deadline. We know that thanks to the filibuster, we need 10 Republican senators. And I believe that part of our ERA strategy must be to remove the filibuster. NOW is always looking at the fact that elections matter. And this is a place where I think, we saw in Virginia that elections matter, and we always have an electoral strategy to elect feminists and to elect people who support the ERA to Congress. Our state and local chapters are always working at the state level to elect feminists to state and local offices, and support of the ERA is always on our criteria for what we need to do. So we'll continue to push forward with our advocacy for the ERA. Last but not least, it will take front and center as a plenary during our national conference this summer, and I hope you all will join us at our national conference. You can get information about it on our website at now.org. Thank you very much.
Thank you very much. And I hope you will, if you can, Bear, stick around in case people have questions. So we just have one final speaker, Sandy. And again, I'm going to ask you to make it quick because we want to move on to the questions and we want Bear to.
I'm all ready to go. Okay. I don't hear you. Can you hear me?
We can hear you great. I'm going to mute myself so I don't
Okay. I did want to just say that I have been doing ERA when other people were not. I can put it that way. Since the 1970s when I marched for the ERA, and ever since. I'm now 87, and I don't plan on dying till they pass this, as I've told legislators. Pass it because you're going to pass it anyway, so do it now. It doesn't work here in Florida. But anyway, I'm going to just tell you, say to you that I am so pleased. I feel very much heartened by the explanations and the kindness and love that I feel from everybody speaking today. I'm so grateful to have this opportunity. And I did start way back then. It wasn't until the late 1990s that we got what do you call it? You can tell I'm 87. No. We got incorporated, and ever since then. And it's been a hard road for us because people who had been eager for ERA were not into the 1980s. And so we were working alone. And it's tough that way. Death threats, public death threats, and being run off the road because it was an unusual ask at the time. But we kept going, and I have a large group that we do things a little differently by computer. We do a lot of talking to legislators. I've just written my 5th letter to President Biden, giving him the reasons that he needs to do this as soon as possible to get rid of the time limit. We call it the time limit because it's not so deadly as deadline. Anyway, okay, I did want to just run by some things with you that you might not have thought of, and it might pique some interest. The actual merits of the Equal Rights Amendment and what it does. I'm going to read it, so make it fast. Once passed into our U.S. Constitution, this noble amendment finally makes sex discrimination a U.S. constitutional violation. One example, public safety, rape adjudicated as the soul-searing crime that it is. Another is fair divorce and child custody, and so forth. Number 2, it's not an entitlement, which we used to hear a lot about. Simply equal treatment for Americans and a worthy principle, nothing more. Number 3, statistics from already ratified states, rates of abortion and divorce are lower there than in unratified states. Girls and women are more than our uterus, after all. But I did want to just put that in there because there's that often comes up. So if you have that statistic that rates of abortion and divorce are lower in states lower there than in unratified states, that's kind of a seller. There are a couple of sellers in here. The Equal Rights Amendment is not dead, number 4, says the Virginia Attorney General James Gilmore. And B, the time limit is impotent as it is not in the votable section of this amendment, but located separately. And I know you've heard a lot about that today. No state's act to rescind its vote for ERA ratification has ever been officially accepted. Our U.S. Constitution does not provide for ratification votes, rescissions, and later reversals of votes. Number 5, economists predict a 15% surge in gross domestic product, GDP. They just today had a big hullabaloo. It's now at 6.45, I think. And the economist's prediction is a 15% surge in gross domestic product, similar to other nations experienced, and seconded by the IMF, the EU, the UN, the OECD, and the GDP would certainly appreciate a GDP boost at this time. 6, this amendment requires no funding and is UN predicted to stabilize communities, lending healing to our nation, which we badly need. 7, legislative staff analyses find no drawbacks to its passage. 8, a recent nationwide survey demonstrates that 94% of all American sectors, That's all religions, all sexes are in favor of the ERA. You can see validated survey comments at www.topassera.org. 9, analyses predict that wise voters, especially women, the nation's majority, may likely flock to polls for those lawmakers endorsing this amendment. I put that in there because I want them to know that we will vote for them if they vote for our ERA. 10, according to amendment wording, passage may not affect corporate donors' bottom lines. That's what they have against it. That's the big one they have against the ERA passage. 11, once Americans find males recognize that it also benefits them, passage will let's see, where did I go? Passage will dissolve common adversity between the sexes. Our overwhelming point is that all Americans will benefit from in the fair, just climate that the Equal Rights Amendment would now undergird. And the last one is activating Amendment 28 will make America's claim to be a representative democracy a bit closer to reality. I hope that's given you some thoughts. And if you want a copy of this, I'm glad to send it along. Sandy O at passera.org. And our organization is correctly National Equal Rights Amendment Alliance, Incorporated 501c3. So that's the whole works of it. Thanks very much for listening. I hope some of it piqued your interest in picking up a piece of it to lean on when you talk to legislators. All right, thanks much.
Thank you very much, Sandy. And we can distribute that along our notes for the town hall. If you, when we send out the notes, we will be sure to include either a link to that or that information in some way. And now we have arrived at the promised Q&A period, and I have the questions here and I'm ready to move forward. Donna had to drop off to drive home, but we've got everybody here ready to answer. And the way I think it should work is this. Tila, if you can hear me, I think now let's go ahead and put all the panelists up on the screen, not just me. So we can
see all of them.
Everybody. And then people can decide if they want to jump in on a question. They will unmute themselves and, we'll be polite and, give each other room to respond. And then go ahead and mute yourself back up when you are not speaking so that it doesn't become a free-for-all. Okay? Ready, everybody? Did anybody need a bio break that's in our panelists? If so, are we good to just barrel onward? Barrel onward? Okay. First question is from Edie Lick. She says, what is the status on states that have rescinded their ratifications of the ERA as far as the necessary 38 state ratification process is involved? I believe that Linda responded to that, but if you want to just reiterate, Linda, what you said previously.
Sure. The historical precedent tells us that you can't take back a ratification once you've made one. And we know that from the 14th Amendment. When the 14th Amendment became part of the Constitution, 2 of the necessary states had voted to take back their prior ratification. And yet all 3 branches of the federal government recognized that the 14th Amendment had become part of the Constitution at that time. And the 2 supposedly rescinding states were listed as having ratified. Why is that so? Well, under Article 5, the states have only one job. It's either to ratify or not ratify. And once they've ratified, they're done. There's nothing in Article 5 that gives a state the ability to go back and have a further impact on that process. It either happened or it didn't. And for all of those states, and there are now 6 who either have attempted to rescind or limit their prior ratification, they all ratified and sent their ratification in to the archivist in Washington, D.C., and that should be the end of it.
Excellent. Our next question comes from Candace Graham. She asks, do we have friends in the Biden administration who can help us move this ERA to the top of the agenda? I personally don't have any connections in the Biden administration directly. So my answer to that is no. Hopefully other people in this have a better answer.
Can I just say, I'll answer very quickly that I think the only way to elevate this is to politicize it, obviously. And that means not so much having a friend in the White House, because I think probably some of us know someone who knows someone. It doesn't matter. You have to politicize it. And to me, that means marching in the streets, uniting, solidarity, large numbers of women making clear to this administration in whatever way we can that this is important to us. I know we can't, it's hard. He's not even getting questions about the ERA at any of his public events where he's speaking. I suggested to someone the other day we should fly a plane overhead at his next public event that has a tail behind it saying, Mr. President, why are you blocking the ERA the same way President Trump did? Like, some kind of shame might help. But I don't think having a friend in the White House is going to change anything. I think, and I've always thought, that neither party actually supports women's equality because control over women's lives and sexual access to their bodies in particular has always been a bipartisan male entitlement. That's why we need to unite as women and not necessarily just march as lemmings behind one party or the other.
Can I add to that, or just piggyback off of that?
Of course.
I just, as far as I don't know. I don't understand why it's all getting thrown in Biden's lap. And believe me, I don't have a problem doing that. But when you had like one of the major women's groups, and I believe it was a law group, I can't quote exactly the title, they didn't even demand the ERA in the first 100 days of the administration. And so, like, how do we go about that? And how do we, keep from being used in that way? Because that's what ends up happening, and the whole divide and conquer thing is real. And we're just trying to survive out here, all of us on our own level, obviously. But, we tried to call into Biden and Harris, they had that on their agenda. They had it on their website. They said
that's actually what somebody else asked is, what is Vice President Harris stated publicly regarding the ERA, and what action is she taking? Because she went on, she said publicly that she supported it, right?
Yeah. Yes, she did. And yes, that was wasn't that one of the, that was brought up in the first presidential debate, during the primaries. And so, I don't know. I just like to see us, be able to get beyond whatever the hell it is that, we get used on both sides. And so it really does have to be nonpartisan.
I totally agree with that.
This is Alice. I think that the reality is it is 100 days since he took office. And he has taken on some major issues. And certainly the Equal Rights Amendment is part of the agenda. And I think we have to give them a little bit of time. They don't even have the Department of Justice all filled with the major staff. So I think we should urge them to act on their positions, but I do think we should be realistic of what they're up against.
Biden is taking the exact same position on the ERA that Trump took. That's what we need to talk about. Even if you want to be a Democrat for all sorts of other reasons, which I certainly do, I am fiercely nonpartisan when it comes to the ERA. If Biden's legal position is the same as Trump's, he needs to be held accountable with our rage. The same rage we felt toward Trump when he blocked the ERA last year, we now need to direct that toward Biden. Never mind this, he's got too many other issues to worry about.
A bunch of rage at Biden going to do for me?
Well,
I mean,
because we have to be political.
Have to come together, but directing a bunch of fucking, excuse my language, directing all this rage that came from Trump, now it's at Biden, that's not doing any good.
We have to politicize the issue, is my point. We have to politicize it the same way we did with Trump. You don't give Biden a pass because he's a Democrat. He's taking the same legal position as Trump.
We're not giving him a pass.
Me, I'm not ever going to give Biden a pass because he's a Democrat. But
Right.
what I'm saying is, absolutely not.
Then we
So
protest.
need Republicans in order to get the ERA passed. So, I have many reasons to rage, but I don't feel like raging at Biden right now because, like Alice said, there are things that are getting improvements done, and taking all the rage that I felt at Trump or at Trump supporters who absolutely are my neighbors and kinfolk is not going to help.
Nothing to do with it. This is about the ERA. He's done nothing. He said nothing. He deserves our focused political rage on this issue.
Wendy, and you're entitled to it, but my rage is not going to be directed at Biden. My rage is directed.
He's the only one we can direct it at right now. There's no other person because politically,
why not? Why not?
Who can help us?
Something other than rage.
I agree with Tammy. Why don't we just call it focus? Why
Focus.
don't we direct our focused interest and collective intellect and collective
energy
capacities?
Yeah, this is my grandson, Carter.
Hi.
Say hi.
When you were just this big. But I think that I agree that let's remove the rage, because that really is just, it's exhausting, it's divisive, it doesn't help anybody because we don't do our best under those circumstances. So let's just use the term. I agree with everybody that's saying let's focus on Biden and focus on this, on ERA and Biden. I agree with that, but rage I don't agree with.
I agree with you. And I did want to just say, didn't Biden create a gender commission? And isn't it mostly for education, in equality in education? Am I clear on that? Can we reach him through that?
Every area.
Let's not get too deep into the weeds on the infrastructure of the new Biden White
I
House.
wondered if we could use it. Could we use that group is what I'm saying.
We
don't
care. On this call right now that are involved with that. We have people, Sandy, that are involved with that group.
Yes.
And you know what Linda and Alice and various people are saying is that it's still sort of shaking out. It's still
I thought so.
Not quite gelled yet. So when we go to say Jennifer Klein, who's somebody that many of us are trying to speak with, or somebody else, until various roles are settled, such as the people indicated by Linda and Alice, I think that just letting them know that we're here and we care and we're watching, and we appreciate them taking care of it is and staying on that, definitely not forgetting it. But I don't think we have to hound them quite yet on the granular level, because it may actually be irritating because they just don't even know where their desk is yet, and they just didn't get even hired yet, potentially.
And it is a hot potato. It is a hot potato politically.
I have something to say though. I think that it's really, really important because you have your lawsuit, EME has their lawsuit, the oral arguments are on Wednesday. And the Biden administration has been in since January 20th. After they got in, the DOJ filed their brief against the ERA and against EME. And then after that ridiculous DC opinion came out in the 3 states case, the DOJ submitted it into EME's case as additional authority, even though it's a lower court and it's full of crap. So you know what? And it also, Biden took away the DOJ's support of the case that was against the transgender students. Okay, so it's not like they can't do anything. They need to stop fighting against the ERA and stop fighting against EME. They could talk to Wendy. They could have a settlement that says, we agree that the ERA is the 28th Amendment, and we're going to have the archivist publish it. The DOJ could do that, and then Wendy could drop her case. That's all they're asking for, is get it published. That's the point of the case. But this is ridiculous to me that they took their support away from another case, and they probably took their support away from other cases from Trump. This is BS, and I'm really, really angry. I did a blog about it. I've been tweeting about it. I've been writing letters to Biden. I've written letters to Kamala Harris. I've written letters to Cece, her husband. I mean, I feel like we, all these people here, if somebody is talking to the White House, they need to talk to the White House, and somebody needs to talk to, like, Vanita Gupta just got put in like a week ago. I called her office to try to get an email so I could write to her. We need to seriously get in touch with these people in the White House, in the DOJ, and ask them to stop fighting the ERA in court. They fought against 3 states too. I mean, that opinion didn't have to come down. If DOJ had done their job and gotten out of it, that opinion would not have happened.
I'm going to suggest that maybe what we ought to do is have a joint letter that goes out every week to the president.
That's a great idea. I like that. I'm writing it down.
Cami, can I just add something about the DC lawsuit, and just to clarify something and give a somewhat different perspective?
Yes, please.
So that I just want to be clear that we haven't lost with Biden yet. And here's why I say that. It is true that the Biden administration was already in place when their brief in the EME lawsuit in the First Circuit was filed. But the only issue they talked about in that brief was the standing issue. So, and I think that's really important. That distinction is really important. The Biden administration did not file a brief that was anti-ERA. What the Biden administration did was continue the position that the prior DOJ had taken on the standing issue. And although I agree that they submitted the DC decision as supplemental authority in the First Circuit, they did it to call out the standing ruling, and that's what they were talking about. So they have not taken a position. I'm not saying that, could they have taken a different position? Absolutely, but they have not, the Biden administration, DOJ has not taken a position on the ERA, on the time limit, on anything like that. They just haven't taken a position yet. And we've just learned this week who the nominee is to head up the Office of Legal Counsel. It was the Office of Legal Counsel that issued the memo. When that person is in place, I believe that they are, and I hope we all urge them to reconsider that opinion. But the Biden administration, as a practical matter, is not going to instruct the DOJ to take a different position. It's just not going to happen, because one of the most damaging things Donald Trump did when he was in office was politicize DOJ in a way that it had never been politicized before. And so as I said earlier, job one of the Biden administration is going to be to restore the credibility of the Department of Justice as an independent voice within the government. And I believe that's what the Biden administration is going to do on this issue. So now that we're beginning to have appointees who are nominated and are going to be confirmed in the Department of Justice, it's really that OLC, the person at the head of the OLC, who's got to act on that memo. And I think that will change things. But I just want to clarify that as of this moment, the Biden administration has not taken a position on the merits of the ERA, on the merits of the time limit issue. It hasn't happened yet.
I don't agree with that.
I don't either, not even a little.
I don't agree with it.
That is absolutely incorrect.
They absolutely have taken a negative position on the ERA in their brief. And putting in the DC opinion is talking about, I mean, one of the main points of this case is that the archivist has no discretion. Even in the DC case, the state said the archivist has no discretion, and they put an opinion.
I agree with that. I agree with that. And that's part of the standing analysis.
Yeah,
I agree with that.
I mean, no, that was not standing analysis. That was him ignoring that he already said he didn't have subject matter jurisdiction, and then he went on and said that. That was bullshit, in my opinion. That's my legal opinion. It was bullshit. But do you know who it is that's nominated for the OLC?
Yes, his name is Christopher Schroeder.
Do you know him personally?
I do not.
Well, I hope that somebody, I mean, I know he's not gonna be able to say anything before he's confirmed. And I hope if this is a good person, do you think he's a good person for it?
I don't know him. And so
I don't know if you knew of him.
I don't know him. But I do know a constitutional scholar who supports our position in these cases, who knows him. And so my hope is that that connection is going to be made as soon as he's put in place.
What about Ms. Gupta?
I don't think she has a role to play in this right now. It's got to be the OLC.
Okay, that's great. We're going to move on to another question. This was very good. I'm really glad that we're talking like this, and I feel great that everybody feels free to say whatever the heck is on their mind. If you don't agree, you don't agree. Everybody needs to hear everything, because you never know what can come out. Okay, this question is from Diana Gray. Thinking about attempts to change and correct systemic racism, sexism, homophobia, would the ERA create legal barriers for the consideration of select groups subject to historical discrimination to seek reparations, material or social, for wrongs suffered if all humans are considered equal, although they may have suffered from a lack of equity in history and in their lives? I don't even know that
I can answer that. I can answer that.
Okay.
I don't know the answer to the reparations question, because I'm not experienced enough in what the legal arguments are that justify requests for reparations. But I can tell you that it won't hurt to have the Constitution declare all persons equal. Might well create a foothold, a legal foothold, for people who deserve reparations to get them. I think reparations are a great idea, and I think women should get damn reparations for all of our unpaid labor that we're still doing. But I do think that once all people are equal, which is not the case. Remember, the reason we're fighting for ERA is because in 1868, when the 14th Amendment was adopted, women were intentionally excluded. And we've been fighting for 153 years to fix the damn 14th Amendment. But I think so long as your country has a foundational document that people perceive to be both legitimate and discriminatory, in other words, the second-class treatment of some people is acceptable under your Constitution, then of course it's a harder argument to make that reparations are necessary, constitutionally speaking. So I think at least you could make the argument that once all persons are equal under the 14th Amendment, when the ERA it becomes law, that will be the law. Then I think the argument about reparations is a stronger one. I also want to emphasize that because of the Bostock decision in 2020, which, by the way, I filed an amicus brief in support of the transgender community in that case, on behalf of EME and the Women's and Children's Advocacy Project at the law school where I teach, we very much support the idea of ERA being a constitutional amendment that will create equality for all. Even though only women were excluded in 1868, we absolutely believe that the word sex covers all, LGBTQ, any form of identity, and so forth. And we feel very strongly about this in part because of what Bostock said in the Supreme Court's decision. They basically said the word sex in Title VII, which is an anti-discrimination civil rights law that applies to employment, the word sex covers all these categories, all ways of being. And we were delighted by that result, both because of what it meant for people, other marginalized communities, and because what it meant to us was, great, now we can get the larger LGBTQ community to help us fight for ERA without worrying that getting ERA through, because it only uses the word sex, would somehow leave them out. Now we were so happy that we could all unite beyond all these barriers that we thought might have been problematic before Bostock. And I'm happy to say that I think that these various communities are coming together around this issue. So there's no question that equality for all is the goal of ERA, period.
If I might interject one statement that I'd like to share with you. One of the things that I find curious as we went through getting the Equal Rights Amendment ratified in Virginia was they were constantly coming up with different things to try and come up with some permutation of a gotcha question that they'd never had before. And one of my most memorable ones was when they said to me, well, you know, the word sex, I don't know what the word sex means. And I said, well, you know, the interesting thing is the 19th Amendment has codified the word sex in the Constitution for almost 100 years. And I've never heard anybody argue that they didn't understand what the word sex meant in relationship to the 19th Amendment. And just by the fact that it has sat in the Constitution for 100 years unchallenged, I think we can all agree that it has basically created its own precedent that all means everybody, that, you know, that's just what it means. So sex and gender, just like words, you know, language is organic. You know, there is a reason we say NAACP and not a National Association of Colored People. And the point is when the NAACP was founded, that was the polite way to refer to that race of people. But our language is changed, and now people who are Black want to be called Black. They want to be called African American. We respect that, and the word colored is like so 1950s. The point of the matter is we're arguing semantics about the word sex when the Constitution has sat with that word for 100 years, and it never became an issue until they were running out of things to complain about. So I think we just don't take that bait.
And on top of that, we don't want to appear before the courts saying sex and be called sexist if it doesn't apply to everybody.
It all means all y'all. That's what we say.
Yeah. I mean, that's the answer right there.
Next question. This is for Curtis Blow. Curtis, are you there? Can you hear me? I know you haven't had any questions. There he is.
Yeah, I'm here.
All right, Curtis. The audience wants to know, can you tell us how you plan to expand your involvement in the Equal Rights Amendment fight?
Good question. Well, I'm a part of an organization called the United Coalition for Humanity, and we deal with many of the systemic racism that is out there, plaguing our people of color all around the world. And we just want to show love to humanity. We love life, we love people, and we support and we enhance and protect the love of humanity. And that is our organization. And we have many committees, like our Criminal Justice Reform Committee and Policing Reform Committee, our Sustainability Committee, Entertainment, Sports, and there is the Women's Rights Committee. And so what we have been doing, we have been meeting for the last 2 weeks on the issues of the ERA and this amendment, and trying to support the EME. I've known Kamala for many years. I was one of the original supporters of the Equal Means Equal organization. And to make a long story short, what I plan to do, I challenge everyone, because I just made a donation, a personal donation of $500 to the EME just now. You can look it up and see. And I want my t-shirt. I want my sweatshirt. And I'm representing 100% for everything that you guys are doing, and count me in. If you need me, I'm there for you. You can get at me at the ucfh.org. That is our organization, and we support you 100%. We're there for you. Amen.
Thank you, Curtis. And we're working on our song, Equal Means Equal. We started working on it back, I don't even know how long ago. We didn't even have any states at that point. And now we're can revisit it and record it and get it out there to the young people. But thank you so much. Okay, next question. This is from Philip Bennett. How does linking ERA with abortion and LGBTQSA rights move us closer to passing ERA when doing so costs us support from Congressman Chris Smith and others like him who strongly support ERA but mightily oppose abortion and or LGBTQSA rights?
I'd like to take this one. It's the position of voteequality.us that the most important thing we do is be transparent and thorough on what things are going to be or not going to be. This is not a hopes and dreams amendment. This is a set of guardrails of non-discrimination that goes into the Constitution. And abortion will continue to be legislated and litigated in perpetuity, with or without the ERA. And so I think we just have to get really comfortable with saying, yes, abortion is going to continue to be legislated and litigated from both sides in perpetuity, with or without the ERA. We shouldn't be backing away from it, but we also shouldn't be saying, here's what it will do or won't do, because quite frankly, that is not up to us as advocates. That's going to happen through the lawyers and the judges and the interpretations. So that's what I have to say about the abortion issue. As far as LGBT+, given the Bostock ruling, we know that all means all. And it is very, very important that anybody advocating for equality is advocating for equality for everyone. On top of that, for some people who are not interested in advocating on behalf of LGBT+ people, one thing I would like for you to consider in talking about the Equal Rights Amendment is that the youth of America does not care that much about women's equality. They care deeply about LGBT+ equality. And it is very important to be keeping this umbrella very large. It's very important to be very realistic about, we do have a Bostock ruling. We do know that this amendment would be used to protect LGBT+ friends, family, neighbors. And on top of that, it is a winning argument for getting the masses on board. And that's what we need to be thinking about. How do we get the youth of America engaged on this? We can't have this won by women only. It has to be women and men. We can't have this won by people who've been doing this since the 70s. It has to be the 20-year-olds too. And so when we start to build a big tent, it needs to be everybody.
And what I had said in my list is that if we've forgotten statistics from already ratified states, rates of abortion and divorce are lower there than in unratified states. That gives us momentum to say that this is not entirely about abortion, like they'd like to say. They'd like to say, oh, this is all about abortion, isn't it? And we can say, no, look at the states that are already ratified.
Or more to the point, I mean, it's not even tangentially about it. I mean, we have multiple states that have attempted to use their state ERAs in these abortion cases, and they have not been able to use them. But I do take what Katie said is really important to hear, is we cannot keep running away from abortion, because we've got to just kind of exactly what Katie said, and I'll just say it again. It's like, this is going to continue to be an issue that's discussed and debated and litigated. but that should not impinge on equal rights for all people regardless of sex, and it should not be used to try and foreclose on that. Okay, next question. This is from Ann Minash of FIST, Feminists in Struggle. We heard from Carol. Carol's still there. Is it better in terms of winning in the courts to have Congress pass a resolution rather than just push Biden to instruct the archivist to publish the ERA? And before we get into this, because this is definitely going to be the WWE part of the thing, let's do a raise hand thing. So we'll do one of you will make a point, and then it'll be 1 point. And then the next person will make 1 point, and we won't just argue over each other. Okay, Arlene's going to make the first point.
Okay, my point is that the resolution is important either way. And the validation, I'm talking about the validation resolution. So it can either be Congress does the validation resolution and tells the archivist to publish, or the archivist publishes, and then Congress still needs to do the validation resolution. That's my point.
Thank you. Who wants to make the next point? Wendy Murphy?
My very quick point about this is that Congress doesn't have the authority to touch the deadline right now, period. And so to me, it's a waste of resources and a lot of political theater. I don't like wasting resources, but if the question is, if they do it anyway, how will it affect litigation? And the answer is, it will kill our best argument. Our best argument is that the deadline is unconstitutional. If Congress passes a law removing the deadline, our opponent's best argument against our best argument will be, how can it be invalid if Congress just removed it? So it undermines our best legal argument. And we're going to need to, no matter what happens in our current case, we're going to need to be making these same arguments in January when we file to enforce the ERA when it takes effect. So I just think it's a timing question. We should be litigating, fighting with our best arguments now and in January, see what happens in those cases. And if we lose, go to Congress. But we're in the courts. The courts have the most power to rule in our favor. They are ultimately going to decide whether Congress acted constitutionally anyway when they go ahead and do whatever it is that they do. So why not procedurally take the steps that we need to take without cutting our feet off? I mean, this is really a serious, serious problem that our opponents have the ability to point to what's going on in Congress right now to undermine our best argument. It makes no sense.
Okay, Linda.
So I respectfully disagree. And that's because having a resolution passed in Congress does not prove or show that Congress had the power to put the time limit there in the first place. If Congress had the power to put the time limit there, then Congress has the power to remove it. Some people may choose to vote to remove the time limit because they don't think it should ever have been there in the first place. But a vote by Congress to remove the time limit doesn't establish that Congress has the power to alter the provisions of Article 5. And the other thing is this: if Congress passes a resolution, whether it's the current version of the resolution that just removes the time limit, or whether it goes further and actually recognizes the ERA as part of the Constitution, there will be an argument that since Congress has acted, the courts should not act otherwise. That is a political question that should be left to Congress. Now, what I will tell you is I think these are all live questions, right? We're in uncharted territory. We haven't had a situation like this on either side. So it's important that none of us make unequivocal statements. We're all talking about arguments we're going to make in court, and nobody can predict 100% how those are going to come out. But I believe that our position in court, and there will inevitably be lawsuits no matter what happens. I believe that our position in court will be stronger if we have this resolution in place. And as to the power of Congress to enact the resolution, even retroactively, I suggest that you go back and look, and I'm sure there's a way to do it, at Kathleen Sullivan's testimony at the House hearing last year, the House Judiciary Committee hearing. She is a constitutional scholar. She was the dean of Stanford Law School, and she testified very powerfully that Congress does have the power today to change its joint resolution, even though the time limit has otherwise passed. So I commend you her testimony, but I do think it would help. And most importantly, I think it's really important that we support all of these possibilities, that we don't undermine the different strategies, and that we all support all the strategies, because we just need to get this done. We're in uncharted territory, and I don't know which strategy is going to work. So let's try all of them.
I agree with that. My only fear is, and I'm not a lawyer, so I don't really have the certainty in myself, is my fear is that we're going to go to court on May 5th, and then this person is going to go, no, go back, start over, girls, don't worry your pretty little heads. And then we'll be like, what? Oh my God, we should have gotten the damn thing published. If it's published, at least there's something to hang on to. Like, we did it, it's there. And then we can say, what do you mean you're saying to go back to the drawing board? We did it, it's there. If this guy doesn't want to put it, I don't know what to tell you, pal, but we did it, and we don't have that. And that makes me so scared. I guess we'll move on to the next question.
Can I just say one quick thing, Kim? The one thing that matters to me about Kathleen Sullivan's testimony, because I certainly watched it carefully, was the deafening silence around this retroactivity issue. The scholars in 1978 that testified about congressional power to affect the deadline, when they said you have to act before it expires, they were very clear that they were talking about kind of big picture constitutional powers of Congress to act at all when a law no longer exists because it expired. Kathleen Sullivan's testimony was roughly this: if Congress can put a deadline in, it can take a deadline out. That is not much of a constitutional analysis. It's a very simplistic view of a very complicated question. She did not address the retroactivity issue. She did not address the concerns of the scholars from 1978, and she certainly did not answer the question, does Congress have the ability to affect a law that expired decades ago? She just didn't. And I'm not suggesting she's not a constitutional scholar. I'm saying she didn't answer the question. So it's important that my opinion is, again, I'll take the ERA any way I can get it, but we have to be smart. And if we unite, not just unite as people, but unite politically using our forces in all branches of government, which is fine. We should be pressuring not just Congress, but also the executive branch, i.e. the president, because he has a role to play here, as does the archivist. We should be pressuring him. And we should be in the courts, pressuring the courts, because all these branches of government have something they can do to help us. I'm not opposed to that. But if we unite without a unified strategy, we may as well be divided. We should have a singular strategy that is not undermined by what we're doing in any of the other branches. That's the only reason I'm saying, not let's never go to Congress, but we're in the courts now. We're going to be in the courts in January. Why don't we focus on the courts? Put all of our resources in the courts and fight like hell until we win or don't win. That's how we got gay marriage. We didn't go to the Congress and the courts. We won in the courts. It was a really important strategy to focus energy in that way in order to make gay marriage a reality. We need to think the way other groups have thought about how to make their fundamental rights a reality, and not being divided in any way, either within ourselves as a group or with regard to the branches of government that we're trying to affect. My opinion, I know people don't agree about this. My opinion is we don't have a ton of resources, and that's a big problem. And so we need to be careful to use our resources in a way that is likely to have the most effect. That's why I feel so strongly about not wasting money in Congress right now.
I just want to say that I did get I did have a conversation with someone, and I'm not allowed to say who it is, but it's somebody who you all know who this person is. And I said, I don't understand how come it was so easy to get the Equality Act, which would seem to me, just being a person on the outside, would seem harder than getting ERA, because it's for very much fewer people. And I said, I understand why it was so easy to do that, and why he can't just call the archivist. And he said, and they said to me, it's because the people that did that, that were behind that Equality Act, they had one voice, and they were like laser focused, intense on that thing. And it kind of was like, oh, okay, we better deal with this kind of feeling from the politicians. And that when he asks people, because to him it's a no-brainer, the ERA is already law, etc., he goes, well, it just seems like there's a lot of disagreement, and people don't really get like what's going on. So like whatever, like we'll deal with it later. And so in that way, I agree with Wendy. I think the problem is that a lot of people want to do the work on the Congress, Wendy, and that's what they enjoy, and that's where they're invested, and they've got a lot of time and energy in that. So to tell them to just stop that and not do it is not a unifying directive. What is a unifying directive, and because of what Alice said about the filibuster and the fact that in the Senate we need 60, so the chances really of us either winning the filibuster or winning 60 votes don't necessarily really impinge on next Wednesday, which is really what is at the heart of this town hall, is that next Wednesday we're facing I don't know what, and I don't really know what to do about it, but I would appreciate like, and then I guess they'll tell us 2 weeks from then if we, so if that disappears, right? Then I say exactly what has come out of this, which is all manners, all roads lead to Rome, all focus, as long as it's ERA. But I would just ask us, given the tenuous nature of Wednesday's thing, if there is anything we can do that would impact that. And I wouldn't really know what it was, save the archivist literally publishing, or Biden just saying, hey, what the heck, just do it, or whatever. If we could do that, because I don't know what else to do about that. Exactly. That's all.
I mean, doesn't somebody have some connection to, I mean, that's why I was thinking Vanita Gupta. I mean, she's number 3. And the idea is, are they still going to keep backing this lawsuit and representing Trump and Barr's position? Because that's what they're doing. And I don't understand that. And I feel like, I don't know when that opinion is going to come out, but we know it's moving ahead, and we know there's going to be an oral argument where the government is going to argue against Wendy, argue against y'all, against the ERA, against the archivist publishing. So they could do a side agreement with Wendy and just agree, okay, the archivist is going to publish. Poof, be gone lawsuit. Y'all can file other lawsuits, but we need to get it published. I used to say that poof, be gone to my kids all the time.
Not gonna happen, but nice pipe
Can I
dream.
say something, please? I apologize. Way back, Wendy, you said something about why not just focus on the court or on the lawsuit. And, Kamala made some good valid points there. But I mean, to us, the deadline is just one more barrier knocked down. And it's almost there. And here we are in the Senate. And, I don't believe that it works against your lawsuit like you do, I guess, is what I'm trying to say. I think it's just one more barrier that, and we've got the separation of power, and, that the courts don't necessarily want to deal with all this. So I just don't really see it as working against what you're trying to accomplish. And, you know, although I disagree with a lot of the way you go about things, I'm not going to say I don't respect you, and I actually do. And I really appreciate the hard work you've done and the hard work you do for children and families and women and, you know, victims, survivors. So I just wanted to put that across there because I know I got real passionate there with you earlier, but obviously we're all very passionate.
Thank you, Tammy.
Yeah,
And I think, you know,
I think it's reasonable for people to disagree. I don't have a problem with that. I just am letting you know my view. And I think Kamala's point about us being focused is vital. It's vital, and we're not focused. And that doesn't mean Congress doesn't have a role, but my point was it's about timing. We can focus on the courts with a very laser focused vision and laser focused arguments, see what happens. And if we lose in the courts, we then go to Congress. There's no reason to go to Congress now because it doesn't help us in the courts. It could hurt us.
But what about the,
guys,
you know,
hey guys, I'm gonna have to wrap it up because it's 5 o'clock exactly. But I just want to finish by saying all of these things are the work in Congress to the degree of Wednesday is moot because there's no way that the filibuster will be eliminated or we'll have 60 votes by Wednesday. And I think that after Wednesday, we can revisit this whole situation about focus and so on and so forth. And I really don't see why again, I was quite heartened to learn certain things, in particular, the fact that once ERA achieves that 2-year validation period, all bets are off. You know what I mean? All bets are off. I demand equality. The rape victim, the pregnant woman that was kicked off her job, the military sexual assault victim. You know, we just start gearing up and for an absolute massive show of force in terms of where are these discriminations? Here they are. Here are thousands of lawsuits about why the ERA must be adopted and enforced right now. That gives me hope because I had the fear that come Wednesday, we were going to have to go back to the Stone Age and start on 100 years of work. And that is clearly not what's happening. So on that note, I feel very good. I thank all of you. If there's anybody that wants to say one last thing before we wrap up, I don't want anybody to feel cut off. Tammy, I know she turned her picture off because she got mad because I cut her off. So
no, my lighting's all messed up because I was in front of the window and I look crazy in this, like,
very angelic. So if anybody has anything they want to say, we're going to send out a follow-up. We thank you. And keep it short. Okay. Yes.
Okay.
Yes.
I have an ask. I'm just asking that the whole idea about sending a letter, a joint letter, if people will agree to sign a joint letter, I hope you will contact EME because I feel like we should send a joint letter to the President, Kamala Harris, to the Attorney General, and send a joint letter and ask them to stop their support of the archivist in that case and settle that case.
So if you draft the letter when we finish this call, I will see to it that everybody on this call gets that and they can respond yes or no. I'll line it up and we'll get it out tomorrow.
Thank you.
Tomorrow.
Please,
And
people sign
Kamala,
off.
Yes.
can I say one thing? This is Curtis.
Curtis.
I just want to thank all of my supporters and co-workers over at the UCFH.org, United Coalition for Humanity. Our executive director, Bishop Kathy Jones, was on the call, and his first lady, Pastor Terrell Jones, and also the legend, Sarah Dash from the group LaBelle. She was also on the call. She was the one who asked me the question, as a matter of fact. And Chaplain Jamila also was on the call, and DJ Flame from New York City. Thank you all for being on the call and chiming in and supporting the ERA.
Thank you, Curtis, and thank you to all of the Curtis supporters. Let's get the word out about what the ERA is and why we need it.
I have one last question, Kamala.
Yes, Carol.
Is the thing on well, Wendy's arguments on Wednesday, are those going to be live streamed? I thought I saw something to that effect.
So here's what we decided to do, because they don't allow us in the courts, they don't allow us to film, they don't allow us to record it. So what we're gonna do is we're gonna make a movie of it, like we're gonna do the Hollywood version where she will present her arguments exactly how she's gonna do it, and then we will show that, but after she's done making them, because if we show it before, we'll get her in a lot of trouble.
Oh,
So
right.
the day of the thing, but it'll be later on in the day from when she actually did it.
Okay. Oh, great. So, and you'll be sending out a link to that then.
That's correct.
Okay.
Yeah, and you know, the public is allowed to listen in on the argument. They can't physically see anything, but you can.
Oh, I didn't know that, Wendy. You didn't.
Oh, is that right?
Yes, but it's okay because, well, yes, you can always listen to public proceedings, like with our
thousands of people to listen so that they know that people care.
Yes, well, we did this with the argument last year in the district court. You basically call in and listen. You can't see anything, but they haven't sent those links out yet. So I don't know. I don't even know that they're going to send a link. I think you just have to log on to the court's website. They send the lawyers a link so that we can see each other and the judges, but people can call in.
Give me your link. Give me your link.
Just go to the First Circuit Court of Appeals website, and I think there's just a very clear way that, because of COVID, they've done this in a very simple way that on their homepage they'll tell you how you can participate. Our argument is Wednesday. We are, I think, 4th or 5th on the list, so the court starts at 9:30. I don't know how much time each of the cases before.
You're on the East Coast, correct? So 9:30.
Yes, yeah, 9:30 Eastern. It won't be right at 9:30 because we're not first on the list. I don't know how much time all the other cases have, but 4th or 5th on the list. So at some point later in the morning, we will start. We have 15 minutes each side.
Social media, as soon as we know, we'll be just like updating people so they don't have to sit there.
And it's a 15 minutes for both sides, but the court is allowed to keep asking questions if they feel like it. So it could go longer.
And who's arguing against you?
The government is arguing against me. It's one guy. I forgot his name. We had a little meeting the other day.
Name so we can know about him.
I forget his name. He wasn't the one who argued last year, but I think he's in the Boston office. Actually, I don't know. He might be in DC. I didn't recognize him and I didn't pay much attention. But it's one man arguing for the government against us. And the panel of judges, I forgot the names. Oh my gosh. I've argued in front of this court several times. And the judge, I know that we have one woman on the panel, Judge Sandra Lynch, and then there are two other judges, two other male judges. And yeah, we should get a decision, I would say, a month or 2 months later at the earliest. That's typical.
Okay, so that's great, because that gives us a little bit of time to really, see what we can do before they make some kind of horrible decision that we have to live with forever.
So the website is the correct one, ca1.uscourts.gov?
Yes, that's correct. Yep.
Okay. I put it in
there's a link in the chat.
Yeah, somebody put it up there.
Says,
Thank you for doing
That's to the calendar though, right?
Is that right? It says YouTube. I don't know if it's just if it's video.
Tila, did you make the chat available for people to be able to copy and download?
I
did. Yeah. You did? Okay. Yeah. So if you can, before you sign off now, we're going to keep this open for a minute to let you download the chat, which has probably a lot of info you want. And then we're going to sign off, and we will be back in touch in a day or so. And we thank you. We thank you for spending all this time with us. It was so generous of you. And let's hope and pray that we get the ERA.